Hello, my dear students. I know you all have been waiting for the revision in English, and here I am. So, today I'll be revising company law, not the entire company law, but a major chunk of it, which is very relevant and very important from your examination perspective. Although Companies Act has been there as one chapter in your syllabus. However, we all know that according to Companies Act, the bare Companies Act, there's a classification chapter wise. So basically, in this particular video, we are going to cover a major chunk which is very important from examination perspective by the institute. So we are going to revise in this particular session the chapter of preliminary, the chapter of incorporation, the chapter of prospectus, and of course our very dear directors, right? So let's begin. Okay, so let's begin with the revision of Companies Act 2013. And if I just quickly take you through the syllabus, which is there, which you have to study, right? So that is basically sections 1 to 122 are absolutely covered in your syllabus prima facie. Of course, maybe in some sections the rules are not covered, some are covered. So we will deal with it that way only. Right. So based on actual classification under Companies Act, if we talk, we have chapter 1 that is preliminary, chapter 2 that is incorporation, chapter 3 which is prospectus, 4 share capital, 5 deposits, 6 registration of charges, and 7 management. Right. So all these chapters are covered in your syllabus. Then thereafter you have certain provisions related to directors, like appointment of directors. Then you have the duties of directors. You have disqualification of directors. You have resignation, removal of directors. So all those topics are also covered with related to directors. Then you have something called as board powers. Then you have something called as appointment of managerial remuneration. There is a chapter called as operational and financial control, in which we talk about board's report, duties of the auditors, audit committee, and like parts. And then we have two very small topics. One is the definition of KMP, which is ideally covered in section 2 only, and one more topic which has been compiled from different sections, that is the rights of shareholders. So one by one we are going to revise everything. Basically, the initial chapters which are included in totality, we are going to revise them chapter wise, and thereafter we will look at the specific topics which have to be revised according to the syllabus, right? So we begin with basically the very first chapter, which is preliminary, right? Now, you have to understand one thing, that what is a company, although this is never asked in examination, but in general, you must know about it. So company, we can understand in two ways. One is the general meaning of company, and the other is the definition of company, right? So the general meaning is nothing but it is a voluntary association of people who have come together for a common objective or profit motive, right? So that is what we mean by company. But if we go by the definition of company as given under Companies Act 2013, what is company? Company is nothing but incorporated under the Companies Act 2013 or any previous laws. So if I talk about that I have a company which has been incorporated under Companies Act 2013, that is going to be treated as a company. But if I say that, okay, I have Reliance Industries Limited, which was incorporated in previous Companies Act, that is also a company even under Companies Act 2013. So all the companies that we have till date who have been registered under the present Companies Act 2013 or previous Companies Act, which was prevalent at that particular point of time, they're all treated in the definition, or they're all covered in the definition of company. So that is one thing, right? Thereafter, we have certain features of company, right? We have certain features of company. So what are the features? The very first one, separate legal entity. Now, company is a separate legal person. That's what makes it special from a general proprietorship, because it is a person, maybe not, maybe definitely not natural person. It is an artificial person, but it has its own separate entity, right? So it has its own separate corporate existence. It is distinguished from the members who have invested in it. It is distinguished from the directors who are actually taking decisions for the company or taking care of its management. No, it is different, right? The next one, we have limited liability. Now, again, although still we have certain companies wherein the liability is unlimited, that is we have unlimited company, and there are also certain cases where the liability becomes unlimited because of fraud and likewise, but in general otherwise we have a company, its liability is unlimited, but the liability of the members of this company is going to be limited to what? Limited to the extent of, if it is a company, limited by shares. So whatever amount as a member I have agreed to contribute, that means supposedly I have agreed to take 5 shares of 100 each, that means I have agreed to give an amount of 500 to the company, right? So my liability is restricted only to 500. Now if I have paid entire 500, there is no unpaid amount left, right? If I have paid 400, 100 is the unpaid amount, right? So my liability or the shareholders can be called only to pay that unpaid value of his shares, that is 100 in the given case, right? So that is the liability which may be asked for, and not more than that. And if it is a company limited by guarantee, then the amount of guarantee is what can be called for. The third one is perpetual succession. What is perpetual succession? No matter who comes and who goes, there will be this company in existence, and it has been legally given birth to, and it is going to be legally wound up, right? Otherwise it cannot happen that, okay, there were 2 members who had invested in the company and the members have died, so the company comes to an end. No, that does not happen, right? The company has its existence from incorporation till winding up, right? It is going to survive, it is going to go on and on and on, right? Then we have separate property. Of course, when we say the company has its separate legal existence, it is a separate person in the eyes of law, then it can also hold properties, it can hold investments, it can acquire land, it can acquire building, right? So it has the power to acquire the assets, transfer properties in its own name. It need not, like if I talk about partnership firm is not a separate legal entity in the eyes of law. So whenever partnership firm wants to buy shares of a company, they cannot buy the shares of the company in their own name. What they have to do is they have to buy the shares in the name of their partner, even though the firm is investing in it, right? So likewise, this the same problem does not exist in case of company. Then we have transferability of shares. What is transferability of shares? If I have invested in the company, I can transfer this investment to someone else also. If I want to withdraw that investment, I am in need of funds, right? So I have bought 4 shares, I can sell these shares to somebody else, right? That means transferability of shares exists. In public company, the shares are freely transferable, but when we talk about the private companies, although there are restrictions, but again, the shares are transferable, okay? Then we have common seal. What do you mean by common seal? Common seal was mandatory before Companies Amendment Act 2015, right? So before that it was mandatory. Now it has been made optional. It is the official signature of company basically. Okay. Now, if the company chooses to keep a common seal, so on every official document, they will affix that common seal. But if they choose not to have the common seal, because now it is optional, then every document is going to be signed by 2 directors or a director and a company secretary, wherever it is appointed. Okay. Next, we have capacity to sue and be sued, which is not written over here, but then that is also something that you must know. So what is capacity to sue and be sued? Now you are a separate legal entity, you can sue someone directly and you can also be sued. The company can also be sued. No matter who I was dealing with, the company has provided me the product which was not up to my mark, I can sue that particular company, right? So the company can also be sued. Next, we go to a concept called as corporate will. Now, first thing you have to understand that what is a corporate will, and thereafter we'll be able to understand the concept of lifting of the corporate will, right? So what is corporate will? It is like a shelter, right? Or basically you can say it separates the members and the entity, right? So it is a kind of privilege that, okay, the company has a separate entity. So there is a curtain, there is a shelter which allows shareholders that, okay, fine, we're safe. whatever is happening in the name of company, and company shall take responsibility. Company will be responsible, although I am signing, although I'm taking decisions, right? So all the shareholders, directors, they're all involved, they're running the company, because company is an artificial person, yet there is a shelter, there is a curtain which is actually protecting the shareholders, which is actually protecting the members. But that does not mean you can take undue advantage of the same, right? So if you are taking undue advantage of the same, you're doing some fraud, that, oh, let me do some fraud in the name of company, I am never going to be responsible. So although there is a separate entity, right, you are separate from that company, but still in certain situations like fraud, what may happen is that this wheel of incorporation, this curtain which exists between you and the company, will be lifted, and you will be held responsible for the actions that company has done. Why? Because we need to punish the persons who actually did wrong, because company is an artificial person, company cannot indulge in fraud. Yes, there can be errors, yes, there can be a few delays and all that. For that, company is going to be liable, company is going to be penalized and everything. You will not be made responsible if company runs into losses for a contract which was made according to your professional judgment. No, the company will bear the loss, right? So that is something else, that is the shelter which you are being protected against, right? But in certain situations, the corporate wheel may be lifted. So what is corporate wheel or lifting of corporate wheel? Disregarding, when you disregard that it is a separate entity, and when the law ignores the company and concern themselves directly with the members or the persons who are managing the company. Okay, now there are many cases in the past where judicially they have passed such decisions that they have lifted the corporate wheel and have held responsible the persons who were running the company, or who have invested in the company, right? So what were the cases? The very first one is trading with enemy, or you can say determination of enemy character of the company. Now, what is an enemy? That you have to understand. Company can be our enemy or our friend, or anyone we are dealing with can be our enemy or our friend, right? How do we decide that? When there is a war, or when the one country is not at peace with the other country, all the persons, all the entities of that other country, they become our enemy, right? So we are not supposed to contract with them, right? So for example, if India is at war with China, or if India is at war with Pakistan, whatever it is, so all those things will settle down for that during the tenure of war. Now during this tenure, you have to understand one basic thing, that there is a company, or let me say there is a company which is incorporated in India, right? Which is incorporated in India. So ideally it is an Indian company. Ideally it is an Indian company, but it has 4 shareholders, and all 4 shareholders, let's say, are Pakistanis, right? Now, if for example, this should not happen, but if for example, India is at war with Pakistan. So all the companies or entities or persons should not be dealing with this Indian company also, right? Because ultimately their shareholders are Pakistanis only, right? So basically this Indian company was protected, or these shareholders were also protected, and there was a concept called as corporate wheel, that you are different and we are different, right? So we will deal with only the company, we don't concern who you are, right? But at certain situations we need to remove this curtain and actually look behind, and we will treat you not as an Indian company but as a Pakistani entity. Why? Because we want to determine the character of the company. So we want to determine and we want to check whether you are an enemy or a friend, because we want to contract or we want to enter into any agreement with you, right? So I hope this is clear. Fine. The second one is laws of taxes and duties, or basically you can say protection of revenue. Protection of revenue. So what is protection of revenue? When the government wants to protect its revenue, right? If you're trying to evade taxes, they will ignore. the separate legal entity status, and they look behind that, okay, who is trying to do that, right? Then we have avoidance of welfare legislation. What is avoidance of welfare legislation? There is a famous case law of associated rubber industry, and that basically says that, okay, there is a company which was earning this much, and because of its earning it had to pay bonus is what? It is a welfare legislation for the labor class, right? So bonus, it had to pay bonus. Now what they did is they diverted this income to someone else so that the profit gets reduced and I have to accordingly pay lesser bonus. Now both these companies, both these entities were merged as one, although they are different, but they were merged as one. Why? Because you are trying to avoid a welfare legislation which is not allowed. Okay. Then we have to protect public policy. Obviously, yes, this goes without saying. And the court will not even take a moment to do this, because if there is a public policy and that has to be protected, no matter what they have to do, they will take that particular action only. Fine. Okay. The next is prevention of fraud. Fine. Prevention of fraud. What is prevention of fraud? Again, a case of Jones versus Lipman. Just a second. See, basically, this is a case where the company is being formed for, I would say, improper conduct. Basically, it wasn't exactly fraud, or you could have called it fraud also. What happened in the Jones versus Lipman case, to be precise, he was supposed to, Mr. Lipman actually was supposed to sell a house, right? But he refused to later on, right? Now, if you go to the court, they can pass an order for specific performance that, nahi, you must sell this particular house. So what he did is he formed a company and transferred that particular house to the company, right? So he could clearly say, no, I don't own the house. The company is a separate legal entity. So in that case, the corporate wheel was lifted. Why? Because the company is used for improper conduct, right? Likewise, we have another concept called as company mere sham or cloak, right? So whether you use the company only for committing some illegal things or doing some fraud, then that is also a case where the corporate wheel will be lifted. It was done in the case of Guilford Motor Company versus Horn, right? And then you have if you do any contempt of court. Do you know what is contempt of court? Disobeying the orders of court. If the court tells you that you have to furnish penalty or you have to submit this particular amount by the end of 15 days, you have to do that. In that situation, if you don't do, the company will not be responsible, right? The people can be responsible, because at that moment the corporate wheel may be lifted by the court, right? So company is an artificial person, it cannot disobey the orders of the court, right? So the persons who are actually managing the company are doing that, right? And the last one, where the company actually acts as an agent of its shareholders. Agents of shareholders means what? A company has been formed and the company is not taking its own separate decisions. It is just the agent of shareholders. So if it's specifically the agent of shareholder, the corporate wheel may be lifted. The next topic that we come across is kinds of companies. There are different kinds of companies, right? So we have mostly types of companies covered in section 2. The definitions are covered in section 2, and we will read them one by one, and thereafter we'll go to the formation of company, right? So the very first one, which is given over here, although we have a lot of categories which it can be categorized into, right? Like based on the number of members, based on control, which is holding subsidiary, associate, right? We have different types of companies. Now, the very first one that we're discussing over here is private company, section 2, clause 68. Okay. Now, what is a private company? Private company basically means a company which has minimum paid up share capital as may be prescribed. Now, nothing has been prescribed. So no minimum paid up share capital has been prescribed. That is point number 1. Secondly, when we talk about private companies, it has 3 things in its articles. What are the 3 things? We have restriction, we have limitation, we have prohibition, right? So there are certain conditions and articles of association of a private company which must be there. What are articles of association? We have 2 fundamental documents of every company. One is MOA, second is AOA. Of course, this is the revision class, so you know this very well, so I don't need to explain you this, but still. Memorandum of Association is the charter document and contains the details about the company. What is the name of the company, with which liability it has been formed, where is it situated, right? Who are the members and everything, right? So that is what is included in MOA. AOA is basically the internal rule book of a company and tells us what are the regulations which the company needs to follow, right? So in every articles of association of a private company, there has to be a restriction that the private company cannot freely transfer its shares. There has to be a limitation that a private company has to have minimum 2 members, but it can have maximum 200 members only. So it limits the number of members to 200. You cannot have, a private company cannot have 250 members. No. If you want to have more than 200 members, up to 200 it's fine, but if you want to have more than 200 members, you have to convert your company into a public company, and then you can do that. But when we are computing this limit of 200, wherever there's a joint member, like me and my husband, we jointly hold a share in a private company. So we will not be treated as two different members. We'll be treated as one member only, right? Secondly, a lot of times to employees we given incentive, and they're being given shares. They're being offered shares under schemes. Now, if I am an employee of a private company, because there are many private companies which continue to remain private, but they're operating on a very large scale, like we have Flipkart, right? So it's not a public company. It does not want that public issue. So it continues to stay private, but it is a huge company. So there might be a lot of employees, might be the number of employees may be in thousands, lakhs, right? So in such a situation, they might be offered some shares. Now, if every employee is to be counted as one member, then there will be so many members. So this ESOP scheme won't work in private companies. So that is why what is there is that these members and these employees who became members, they'll be entitled to all the benefits of members. It's just that they will not be counted in this limit of 200. So they acquired this membership, they acquired the shares while they were members. They'll not be counted in the limit of 200, even if their employment ended with the company and they continue to be the shareholder of the company. Still, they become the former employees. Still, they will not be counted in the limit of 200. So this is one thing that you have to remember. So every private company is going to have the restriction on transferability of shares, limitation on the number of members, and prohibition that it cannot invite public to subscribe for any securities of the company, whether it's debentures, whether it's shares, or anything like that, right? So this is about a private company. We add suffix private limited to a private company, and OPC and small company is also a private company. Then we move to the next part, which is a public company. What is a public company? Public company, which is not a private company, is a public company. So simple, right? And having minimum paid up share capital as may be prescribed. Again, there is no minimum paid up share capital which has been prescribed. Okay. There is one thing that you need to remember in the concept of public company, and that is deemed public company. Deemed public company, what is it? So we have a subsidiary of a public company. Okay. Now you have to understand that private company has lesser compliances to do. It is not exposed to a lot of things that you have to follow this, you have to disclose that. But public companies, because they are also open to public issue and they might have public money and all that part, right? So they have a lot of disclosures to make. Now, supposedly there's a public company which has even gone for IPO and has a lot of public money. And when they have taken that money, they have invested that money in the private company. Now, that private company is not supposed to report anything. So this becomes a problem. So to avoid this particular thing, what has been said that if you are a private company, but you are a subsidiary of a public company, then you will also be deemed to be a public company. And now you will not enjoy any exemption benefits which are given to a private company, but you will have to comply with all the requirements that a public company has to do. Okay. So this is a subsidiary of a public company is deemed to be a public company. That is one thing that you need to remember. Okay. So I hope public company, this is clear. Fine. Now, the minimum number of directors in a private company is 2, and in public companies, it is 3, right? There are a lot of differences that you will eventually explore in private and public companies. The next concept that we come across is Section 2, Clause 62, one-person company. Now, OPC was not in existence before. Okay, so although there was a concept of one man company, but otherwise this has been a newly introduced concept under Companies Act 2013, and this has immense benefits because the individual entrepreneurs who do not have multiple people to come together and form a private company or a public company, because in public company you need at least 7 persons, and in private company also you need at least 2 persons, right? So the ones who do not have a lot of people, what they can do is they can form a one person company. So it helps the individual entrepreneurs, right? What they get is they get the benefit of limited liability, they get a lot of legal protection, because that is company will be separate, that will be separate. Companies get better credit facilities and access to market, right? There are a lot of opportunities. If you're working in the area of handicraft, or you're a weaver, artisan, you can always form a company, and it will give you an opportunity to start your own venture with a proper corporate formal business structure, right? So it has huge benefits. Moreover, if I talk about OPC, there are lesser compliances. You don't have to hold that AGM, right? Lesser compliances in terms of you don't have to file less returns. The annual return is shorter, right? The board's report is shorter, right? So balance sheet, you are not supposed to prepare cash flow statements. So there are a lot of compliances benefit also which you get, right? Apart from that, if although we will discuss it in chapter 2 when we discuss about incorporation, and there is a section 122 which also tells us that a lot of things are not going to be applicable on OPC. So of course OPC has tremendous benefits. Now OPC can be registered as a company, as a limited company, limited by shares or limited by guarantee, right? But OPC will always be a private company. It cannot be a public company. So OPC is a type of private company with some special features. What are the special features? There is just one member in the company. So there are very high chances that this one member may become incapable to enter into a contract or may die. So what will happen? All the shares get transmitted to the legal heir, but still there will be a problem to run the company because he is the sole person, and in most cases he is the sole director. Okay, so what happens? There could be a problem. So in such a situation, OPC has been designed in such a manner that you have to have a nominee. Okay, so the memorandum of association of OPC company will also indicate a name of nominee. So you obtain somebody's prior consent that, are you ready to become the nominee of my OPC? The person says yes. There's no qualification required to become the nominee. Any person can become the nominee, right? That person should not be a minor. He should be at least be competent to enter into a contract, and there are certain requirements which eventually we'll discuss. If I want to form a one-person company, I need to be a natural person. A company cannot form another OPC because the concept originally is for the individual entrepreneurs, right? So I have to be a natural person. I have to be an Indian citizen. I may be a resident of India. I may not be the resident of India. There are many errors in different materials regarding this update and amendment which came long back, right? But remember, this is what you're reading is correct. Okay, so he may be a resident, he may not be a resident, and that particular person can incorporate a one-person company, and you have to find another such person. That means a natural person, an Indian citizen, whether resident or not, to become the nominee. You ask that particular person, are you ready to become the nominee? Obtain his prior written consent, and along with the consent, you submit this and write the name of that particular person. If the sole member becomes incapable to enter into the contract, or if the sole member dies, then that nominee will take place of the sole member, right? So the perpetual succession concept will actually be intact. Okay, one person cannot incorporate more than one OPC. You cannot incorporate two OPCs. So you cannot be a member of two OPCs. You cannot be a nominee of two OPCs, right? And all details we will discuss when we actually go on to the incorporation part, right? OPC cannot be incorporated as a Section 8 company. What is a Section 8 company? Section 8 company is a company which has been formed for charitable objects. Okay? I hope so far the things are clear. One more thing that you need to remember, that if you're talking about one person company, you cannot invest in any body corporate. It's not allowed. That means you cannot buy shares of another company. And likewise, no company can invest in you, because the only sole member who can invest in you is an individual, right? So basically, OPC cannot be a holding, OPC cannot be a subsidiary, because you're not allowed to invest in the securities of any body corporate, and you are not allowed to carry out NBFC activities. Non-banking financial activities, they're not allowed, right? So there are certain restrictions. You cannot be a Section 8 company, you cannot carry out NBFC activities, you cannot invest in anybody's corporate, okay? So these are the things that you need to remember. And basic benefits, I've already told you. There are more detailed exemption benefits that we'll discuss later. Okay? Fine. There is no concept called as compulsory conversion of OPC into a public or private company now. That has been deleted way back. Okay? So even if you find it somewhere, please don't read it. Fine? That does not exist as on date. Okay? The next concept that we come across is holding company, right? Okay, what is a holding company? Basically, when we talk about holding, subsidiary, associate, they're all based on control. So holding company does not have a proper definition in itself, but when we talk about subsidiary company, we'll understand holding company as well, right? So what is a subsidiary company? Subsidiary company, if there are two companies, okay, because this is a relative concept, you cannot understand this standalone. You can say this is a private company, that is a public company, but you cannot say this is a subsidiary. This is a subsidiary in relation to whom? Like if I say I am a mother, I'm a mother to my child, not to everyone else, right? So when you say subsidiary is a relative concept. And if I say subsidiary, there will always be a holding. And they have a holding subsidiary relationship. It's not a subsidiary to somebody else, right? Some other company. So when I say subsidiary, then there is a holding company which actually either controls the composition of board of directors or exercises more than half. So even if it is 50.01001%, then that is also a subsidiary. So if one company, let's say, has 50.04% shares in another company, we will say this company is holding and this company is subsidiary. Why? Because shareholding or share capital is as good as voting power unless DVR shares are issued, differential voting rights shares are issued, which we actually get to know later, right? So in the chapter of share capital, I'll explain you that, right? But as of now, if one company, and this is a concept of holding company and subsidiary company. So I cannot say that if I am an individual shareholder and I hold 60% shares in a company, I'm a holding company. And that, no, I'm not a holding company, right? So there has to be a body corporate for establishing this particular concept, right? Now, if one company either controls the composition of board of directors, that means that company is appointing, that company is removing, right? So they have a good control over the who is going to be the board of that particular company, or exercises or controls more than half of voting power. Now, this more than half of voting power could be individually or could be together with its subsidiary. What do we mean by that? Let me take a quick view. We have a company A Limited, and A Limited holds 70% shares, let's say, in B Limited. So A and B have a holding subsidiary relationship directly, right? Now B Limited holds 40% shares in C Limited, and A Limited holds 15% shares in C Limited. Now, if I try to establish the relationship between A and C, they're not holding subsidiary prima facie or directly, right? Because A Limited holds only 15% shares in C Limited. However, A Limited has a control of 15% plus its subsidiary also has a control of 40%. So if I sum total 40 plus 15, it comes out to be 55. So together you have a control of more than half of voting power with your subsidiary. Then they also establish a relationship of holding and subsidiary. Fine. I hope this is clear. Okay. Now there is a restriction given in law. What is that restriction? That you cannot have more than 2 layers of subsidiaries. One thing you have to understand, that one company can have n number of subsidiaries. That is not the restriction, right? So if I form a company A Limited could have a lot of subsidiaries. The problem is in layering, right? That is, the subsidiary of A Limited is B Limited, the subsidiary of B Limited is C Limited, the subsidiary of C Limited is D Limited. So layer 1, layer 2, layer 3, that is how it goes, right? So you cannot have more than 2 layers of subsidiaries. However, if you're a banking company, NBFC, insurance, or government, then this restriction does not apply to you. Okay. Now, when we come to the holding company is very simple. What is holding company in relation to other company? Is a company of which such company is a subsidiary company. So that is very simple. Now we come to the next part, which is associate company. What is an associate company? Associate company is the mid, right? Like, you cannot become the subsidiary because you don't or if I am a holding company, or if I am a company, I am holding, let's say, 30% shares in another company. So that company does not become my subsidiary. Why it does not become your subsidiary? Because you need to have more than 50%. So you don't have that much control or that much voting power. Yet you have a significant influence. What is the significant influence? Having a control or at least 20% voting power. 20% or more. So if I am a company and I hold 21% shares, 20% shares in that other company, then that company, it is called as what? Associate company. Okay, so if it becomes your subsidiary, then it will be called a subsidiary only. But if it is not subsidiary, but you have significant influence, then that is what is called as associate company. I hope that's clear. Okay. The next concept that we are reading over here is the concept of small company. What do we mean by small company? Very popular among students, because we have seen a lot of recent amendments amendments in small company. Section 2, clause 85. Now, what is a small company? Small company is nothing but a type of private company first. Okay, so a private company, if it operates on a small level, that means it meets certain prescribed thresholds, it is operating within that threshold, then it is called a small company. And small company have a lot of benefits. So first thing, if you're a public company, you cannot be a small company. If you're holding company, that means you are investing in in securities of some other body corporate. No, you're not a small company. If you're a subsidiary, that means somebody is investing in you. You're not a small company. So if you're a public company, you're not a small company. If you're holding company, you're not a small company. If you're a subsidiary company, you're not a small company. A Section 8 company already is entitled to a lot of exemption benefits in different ways. It will not be conferred the status of being a small company. And if you're a company which is governed by special act like Insurance Act, right? So you're not a small company. So these 5 types of companies will not be treated as small company other than this. So if you're a private company, other than these, and you meet a certain threshold. What is the threshold? See, the current prescribed threshold is that your paid up capital should not exceed 4 crores and your turnover should not exceed 40 crores. Not to exceed 4 crores or 40 crores. Right? So this is what is being prescribed. Now you have to understand very well, because students get confused and they mess up everything. So understand one thing very clearly. When we're talking about the definition which is stated in section 2 clause 85, what does it say? Small company means a company other than a public company, right? So small company means a private company. Paid up capital of whose does not exceed 50 lakh or such higher amount as may be prescribed, which shall not be more than 10 crores. So the maximum amount which may be prescribed can be 10 crores. Now we have to see that paid up capital should not exceed 50 lakhs or such higher amount as may be prescribed. CG has the power to prescribe this amount up to 10 crores. CG has used this power and prescribed an amount of 4 crores. So 50 lakhs or such higher amount as may be prescribed. So we have a higher amount prescribed, 4 crores. So we say that paid up small company means a private company, paid up capital of which does not exceed 4 crores. You get it? But when you're writing the entire thing of the definition of small company, you must write the entire thing. Okay. Secondly, and. So it is a twin condition compliance. You have to comply with both the conditions, then only you can proceed forward. Right? So what is the other condition? Turnover of which does not exceed 2 crores or such higher amount as may be prescribed. It shall not be more than 100 crores. So CG has the power to prescribe turnover up to 100 crores. CG has used this power and prescribed the turnover of 40 crores. So 2 crores or 40 crores, that is the higher amount prescribed. Okay, so I hope this is clear. Moving to the next type of company, which is Section 8 company. What is Section 8 company? Section 8 company is a company which is formed for charitable objects, right? Charitable purposes like you can say commerce, science, arts, sports, education, research, charity, religion, okay, environment, and a lot of other things. How do you form a Section 8 company? Firstly, Section 8 company is formed not for profit motive. It is called as a non-profit company, right? See, whenever we are talking about NPOs, whose intention is for the betterment of society and not for profit motive, they can be formed either as a trust, you register the trust, or they can be formed as cooperative societies, or they can be formed as Section 8 companies. Okay, so Section 8 company, of course, comes under Companies Act. Earlier, we had Section 25 under Companies Act 1956. Okay, now we have Section 8 companies under Companies Act 2013. Okay, fine. They don't need to use the suffix limited, private limited. They can be formed as a private company or as a public company. That's it. It's not a problem. They cannot be formed as OPC. Now, because they are formed for charitable purposes, they cannot utilize their profits in filling their pockets, right? It cannot be distributed as dividend to the members. They have to, if any surplus is generated, they have to plow it back to the purpose or to the object only. Fine. So prohibition on payment of dividend. There is no minimum number of directors required, because if it is formed as a private company, there will be 2 minimum number of directors. If it is formed as a public company, there will be 3 minimum number of directors. But in case of Section 8 company, this is not the case. Fine. We have a lot of other things to read about Section 8 company, like how do we obtain license, etc., etc. But we'll be doing this when we discuss about the incorporation part. Fine. Then we have government company. What is government company? My dear, government company is different from government department. First of all, you have to note that down. Okay. The second thing, if we are talking about central government as well as state government. So if central government or state government or a combination of them, 2 state governments, central government and 1 state government, whatever it be, right? Or many state governments, they hold at least 51% of paid up share capital. At least 51%. Or you could say 51% or more. See, when we are talking about the definition of subsidiary, it was more than 50. So even 50.01% counts over there. But here you need to have at least 51% of share capital. If it is held by government, doesn't matter, central government, state government, or jointly by both of them, then that particular company is going to be called as a government company. Now, whenever, let's say central government holds shares, like we have ONGC. So when you open the shareholding pattern of ONGC, what you will see is that the shares are in the name of president. So when the shares are being held by central government, they'll be in the name of president. And if they're held by central state government, they'll be in the name of governor. Okay. So no specific person that currently I'm in that position, so the shares are in my name. No, it is in the name of office. Okay. Next, if you have a subsidiary of ONGC, then that will also be treated as a government company. So subsidiary of a government company is also government company. Okay, fine. Then we have something called as a foreign company. Fine. What is a foreign company? Now, foreign company is a company which is incorporated outside India, but It has a place of business in India and conducts business activity in India. Now, this place of business in India could be a direct place of business or could be through an agent. It could be a physical place of business or it could be an electronic place of business. Like what, ma'am? Like, let's say we have somebody in US who is imparting education through online like this only. Do they have a place of business in India? The answer is yes. They have an electronic place of business in India. Electronically, they have established a place of business because they are doing business in India. They're conducting business activity in India, right? They're imparting education over here. So that is what. Will it be called as a foreign company? The answer is yes, because if you're incorporated outside India and you're doing business outside India only, we're least concerned, right? Indian laws are not going to be applicable on you unless you want to raise funds from here, right? So we have a separate chapter for that. But otherwise, if you are a company outside India and you're doing some business in India, you have a place of business in India. Maybe it is a physical place, maybe it is an electronic place, maybe you have opened a place, or maybe you have hired just someone and that particular person is selling your product. So you have a place of business through as your agent, right? So it doesn't matter, you will be called as a foreign company. Okay, now this electronic mode has also been defined, like you have any digital supply transactions, you have telemarketing, telecommuting, telemedicine, education, as I told you, right? Any cloud computing, any data communication, right? Voice transmission or whatever, they're all inclusive in the definition of electronic mode. Okay, now what you have to understand, because there are a few more sections which are being given over here. Firstly, when we are talking about place of business, you have to understand that if there is a company and that company is having a share registration office over here or share transfer office over here, that means whatever transfer deeds they receive, the transfer is being executed at a place here, then that will be treated as having a place of business in India. Okay, it will be treated as having a place of business in India. There was another case law, there were some representatives of a company. There was a company which is incorporated outside India. They came to India frequently. They visited India and stayed in a hotel, right? They were actually looking for a business deal, right? They were wanting to purchase some machinery, purchase some articles, and they stayed in that particular hotel, right? Every time they came here, they stayed in that hotel. It was held that that hotel is also a place of business. Okay, so you have to understand that. Now, we have few concepts that we need to understand. Concept number one, that section 380, we have a separate chapter for companies incorporated outside India, and we don't have to read the chapter in entirety. It's not included in our syllabus. What we have to read is one section, section 379, some part of it, and we have to understand and know that there are two sections, section 380, section 381. Section 380 tells that you must deliver certain documents to ROC. Which ROC, ma'am? Maybe it is having some electronic place of business. There is a company incorporated outside India. It can work in India by forming a subsidiary also, by forming an Indian company also. Then that case, it is not treated as a foreign company. That Indian subsidiary becomes an Indian company only. But let's say, for example, there is a company incorporated outside India. It opens a branch over here and is selling goods in India. So that particular company is going to be treated as a foreign company, and that company has to comply to certain things and follow certain Indian laws. So we have a separate chapter for that, out of which we have to read certain portion. One, that if you open a place of business over here, there are certain documents that you need to furnish to ROC New Delhi. Okay, so for all foreign companies, we have ROC New Delhi. Second thing, which we have section 381. Section 381 tells us that you have to maintain certain accounts. Like the Indian companies prepare and maintain books of accounts, right? Likewise, you also have to prepare and maintain the books of accounts. Okay. The third thing is the concept of deemed Indian company. What is deemed Indian company? Now try to understand this with focus. Okay. What is deemed Indian company? Let's say there is a company which is incorporated outside India. Okay. And it has certain shareholders A, B, C, and D. Okay, it has certain shareholders A, B, C, and D. Now, out of these, B is an Indian, C is an Indian, D is an Indian. A is not an Indian. Indian means citizen of India. That particular person may be NRI, doesn't matter, you're a citizen of India. So they are all three Indian citizen, or let's say there are four friends, they were living in India, they are Indian citizen, they moved to US and there they incorporated a company, so they are still Indian citizens, right? So out of these, three are Indian citizens. A has 10% shares in the company, B has 20% shares in the company, C has 50% shares in the company, 5, 6, 7, 8, and again D has 20% shares in the company. Okay, is this clear? Now this particular company opens a branch in India. That is, you can say establishes a place of business in India. So this company will be called as a foreign company, yes or no? So far, I hope the concept is clear. Now you have to understand another concept, where at least 50% of the paid up capital of this foreign company is held by Indian citizens, Indian companies, or in a combination of the two. Then that particular company is treated as deemed Indian company and it has to comply with certain additional provisions as if it was an Indian company. So it has to comply with the provisions of this chapter and some other provisions what may be prescribed as if it was an Indian company only. So in the given case, if we look at this, 90% of the shares of this company is held by Indian citizens. So this establishes the concept of deemed Indian company. See, if 50% or more paid up capital of such company is held either by Indian citizens or and company or body corporate incorporated in India, then this particular chapter and some other prescribed provisions will apply to the company as if it was an Indian company in respect of its Indian business. So I hope this is clear. Okay. Then we have listed company. Listed company. What do we mean by listed company? There are certain companies which are listed, there are certain companies which are unlisted, right? So we have recognized stock exchange. It is nothing but like a marketplace. So if I am a company, I have issued certain securities to general public, it is mandatory that before issuance, I have to apply to the stock exchange and get the listing done, right? Because if you are offering shares or securities to public, it is the duty to provide them a platform to sell it, to buy it, right? So it is nothing but a platform. Like if I want to sell my product, I have to get my listing done on Flipkart. It's as simple as that, right? Of course, there are technicalities, but the concept stands very simple. So there is stock exchange, we have NSE, we have BSE, right? Two broad famous stock exchanges. Now, if any of your security, it doesn't matter, all of your securities, a company is not listed, its securities are listed. So if any of your securities listed on a recognized stock exchange, then you are called as a listed company. Okay. Now, there is one more thing that you need to understand. What is that, ma'am? There could be a private company also whose debt securities might be listed on a stock exchange platform. It is allowed according to SEBI regulations, right? Not the shares, but a kind of debt securities that is allowed, right? We don't have just one platform on stock exchange. We have the main board, we have SME, we have IGP, that is Innovators Growth Platform, wherein people or companies look for angel investors and like, right? So there are cases. Secondly, there may be a situation that I'm a public company, I have issued equity shares, I have issued debentures, or I have issued preference shares. I have not done the listing of equity shares. I have listed my non-convertible debentures, which will never convert into equity. I have listed my non-convertible debentures on the stock exchange. I have not listed my equity shares. Okay. Thirdly, I am a public company. I have not listed my shares on any recognized stock exchange in India, but have listed it in a foreign jurisdiction. That means stock exchange of US. right? There the trading is going on. So in all these specified cases, that is, if I am a public company and I have listed only debt securities or preference shares on private placement basis, which I issued on private placement basis, right, and not my shares, or if I am a private company and I have listed my debt securities which I issued on private placement basis, in all these cases, for the purpose of Companies Act 2013, these companies will not be treated as listed company, only for the purpose, because once you become a listed company under Companies Act, you're subjected and prone to a lot of other compliances, right? So to stop that, okay, fine. Financial year and KMP, basically I'll be discussing financial year as and when required, and KMP at the end. Now, there is one more thing that I need to discuss. What is that? It is producer company. What is producer company? Actually, I would say we have Companies Amendment Act 2020, and it has actually notified producer companies, and we have section 378A to 378ZU. They deal with the producer company, right? So what is producer company? It is nothing but it is a group of farmers or agriculturists, right? So they have come together and their association is legally recognized as a producer company. They are producers, right? So when they come together, and what is a company? It is a voluntary association of people with a common objective. So all the farmers have a common objective, all the agriculturists have a common objective, right? What is their aim? Their aim is to improve the standard of living and etc., right? So they have come together, and that is, if your objective is that, if your objective is production, if your objective is harvesting, if your objective is grading, pooling, or you can say even some research or training in that particular field, right? If your object is harvesting, processing, insurance of primary produce, other welfare measures, providing education, supply of machinery, etc., then if you have that particular object, then that is called as a producer company. So the object of producer company are given in section 378B, and which you should learn, right? Because that's the only thing that you have to learn with respect to producer company. You don't have to read all the sections, but whatever sections you have to read, you'll do that, right? Okay, so next we will start with, okay, I don't think I discussed with you about PFI. PFI is one such thing that I want you to know. What is PFI? Public Financial Institutions, Section 2, Clause 72. There are a list, 5 institutions which have been there. LIC, then we have IDFCL. What is it? Infrastructure Development Finance Company Limited. Then we have UTI, Unit Trust of India. Then we have all those institutions which were notified by central government under Companies Act 1956, and other institution which may be notified by CG in consultation with RBI. Now, CG cannot notify any financial institution as a public financial institution. When you add public, it denotes like it belongs to the government. First thing, right? So if there is any financial institution, first thing, it has to be established under Central Act or State Act, like LIC established under LIC Act, okay? Or there should be a situation that at least 51% capital is with the central government or state government, because it gives you an impression that this belongs to the government. So it is a financial institution rendering financial services, but it belongs to the government, okay? So it may be recognized, it may be notified as given. Fine. So I think so far the things are clear. Okay. So we will next begin with the revision of incorporation of companies. Let's now revise the chapter of incorporation of companies and matters incidental thereto. Ideally, if we see, it is chapter 2 of Companies Act 2013, which starts from or comprises of sections 3 to section number 22, right? Okay, and of course the rules to go with it. Now, very first thing that you have to understand is section 3. Okay, section 3 basically tells us how do we form a company. The first thing that it tells us that a company may be formed for a lawful purpose. It simply implies that if you choose this particular form of business organization, you can make this type of company only for a lawful purpose. And there are 3 types of companies which may be made. If you want to make a public company, then you need to have at least 7 persons, 7 or more persons are required to form a public company. If you want to form a private company, then you need at least 2 persons. And if you want to form an OPC, then only 1 person is sufficient, right? So a company may be formed for a lawful purpose. These are the 3 categories of companies which can be formed. And if you want to form a company, all you have to do is subscribe the name to the memorandum, comply with all the requirements which are given under the Act, which basically we read in section number 7. So in section number 7, we read the detailed procedure of incorporation of a company. Section 3 only tells us how a company may be formed. So it tells if you comply with all the requirements, a company will be formed. Fine. If I'm talking about OPC, it also tells us that in case of OPC, you also need to have a nominee. So you obtain his prior consent in the prescribed form and you state his name in the memorandum of association. If at all the sole member dies or becomes incapable to enter into a contract, then what will happen? The nominee's name that you have given will take his place and he will now be the sole member, right? So that is what is being told to us. And once you have complied with all the requirements, ROC, Registrar of Companies, of which we have a basic idea, and now is not the time, revision is not the time to give you all those details, right? So what ROC will do, ROC is an authority which is actually meant for keeping all your records, right? All the records relating to the company, right? To facilitate the whole process of incorporation. So they get all those documents, they allot you a certificate of incorporation, they give you a corporate identity number, which is also known as SIN. The short form is SIN, right? And we need to preserve all the documents till the dissolution of the company, right? So that is what the formation is all about, right? Now we'll start with the entire process. These are some basics which are given in section number 3. Now we'll start with the entire process. Okay, so you need to have some basic idea about the promoter also. Who is a promoter? See, if I want to form a company, I am a person who gets the idea. Okay, I want to start a factory and I want to form a private company. So I'll be needing 1 more person. So 2 persons, maybe we can start a company. Now I have just this basic idea. I go to a chartered accountant or I go to any other professional and I tell them that, okay, I want to form this particular company. Now they are actually providing me assistance, right? So they are professionals who are actually helping me out. So they are not the promoters, we are the promoters, right? We are the promoters as in me or my friend, or maybe I could only be the promoter. I have arranged more people, I have arranged funds, I have prepared the documents. So the person who is doing all those tasks, that preliminary steps of gathering people, preparing the documents, deciding the name of the company, doing the filing, entering into pre-incorporation contracts, that particular person is known as basically promoter, right? Now, promoter may change during the lifetime of the company. Right now, or maybe let's say when Reliance was incorporated, of course, there was Dhirubhai Ambani. Right now, does he exist? No. So that means the company does not have any promoter? No, the company still will have promoter. What happens if now the company is in short of funds? Who is arranging the funds for the company? It's not just the directors that they're doing everything. There is still the need of that upper hand promoter, right? So who is still taking all those efforts? It is the Ambani family. So they are the promoters, right? Even under SEBI regulations, you need to write about the promoters, right? Okay, let's not get into all that. So the definition of promoter is defined in section 2 clause 69, which simply states that promoter is somebody who is named in the prospectus. So if you want to know that who is the promoter of this particular company, his name will be written in the prospectus wherever it is issued. His name will be written in annual return. So by seeing at that, you can get to know that this particular person is the promoter of the company. Secondly, he will have control over the affairs of the company. Maybe he is the promoter, he has 60% shareholding in that particular company. So because of that shareholding, he has a good control on affairs, right? Or otherwise also he might be the MD, right? Or he might have just a contract with a company that I'm going to take these decisions, right? So somehow he is controlling the affairs. Or the third situation could be that board of directors are acting according to his directions, right? So board of directors is accustomed to act according to his direction. So in all the 3 cases, he is going to be the promoter, right? Okay. Now, So before the company is actually incorporated, promoter is somebody who selects a name. Now, how do you select a name? You need to comply with section 4. You need to comply with rule 8, right? Rule 8A, rule 8B. And there are a lot of words which are being clearly given, that we have rule 8, which says that these are the list of undesirable names or undesirable words which you cannot use in the name of the company, right? So whenever I'll slightly skip this part, and I'll actually first take you to the process of incorporation, which is name reservation, right? So you are trying to select a particular name, right? How do you select a name? The name should not be identical or resemble to an existing company. If there is already an existing company in the name of Reliance, I can never get the name of my company as Reliance, because it will give a presumption to people that, okay, there is another chain, another company which the Reliance Group has opened. No, right? So that will not be allowed. Secondly, it should not constitute an offense. I am abusing someone in my name or demeaning some community. No, that cannot happen, right? Third, it should not be undesirable according to central government. As I told you, there is rule 8A, which actually gives us a list of this. We have rule 8, which tells us that what is not going to be considered as resemblance and all that, right? You don't have to read all the rules in a lot of details, fine. Then we have another part which says that there are certain words which can be used only by a government entity. Like if I use the word board in the name of my company, like we have central board of something, it gives us an impression that, oh my god, this belongs to the government. So if I am opening a private company and I'm using such terms which actually gives an indication that it belongs to the government, no, my dear, we cannot use that, right? And if we want to use that, we need to obtain CG's approval. So we cannot use this, we cannot use this, we cannot use this, and we can use this subject to approval of CG, right? So this is how we actually decide what name we want to get. The process is entirely automated in the current scenario, right? So we have a beautiful form, Spice Plus, which is divided into two parts. Part A is for name reservation and part B is for furnishing the entire set of documents. So when we are filling part A, they can be filled together also and they can be filled separately also. Once your name is reserved, then you can also fill part B, which is advisable, right? So part A, you give in the basic details, you suggest a name keeping in view all these restrictions, and then the name is approved. So that is the first thing that happens. That is the first thing that happens. Okay. So you file it with ROC. Supposedly your application form has no defect, your name will be approved and your name will be reserved for 20 days from the date of approval, which can further be extended. 20 plus 20. Okay, just a second. For 20 days, then for another 20 days, or at once for 40 days, right? So this can be done. This can be done. Now, if there is defect in the form, then you are being given a choice. You're being given a chance to rectify that particular defect. And if you rectify the defect, supposedly you haven't given this particular information properly and ROC asks you that fill this information properly. So you fill it and submit it within 15 days. They can still approve your name reservation application. Otherwise, it will be rejected. Okay. Supposedly you thought that, okay, I can get this particular name only if I am a construction company. So although you don't want to do that construction business, you're not a construction company, but you provided some fake information and false documents and you got this particular name. That means you have reserved your name by furnishing some incorrect particulars. In that situation, there might be two cases, right? One is that you just filled part A of Spice Plus, right? You haven't filled part B. The company is not yet formed. Only the name is reserved. So what will happen if it is found that, oh my God, the information that you submitted was not correct? So they will cancel your reserved name and they will impose a penalty. ROC will impose a penalty of 1 lakh on the promoters, whoever is making an application, right? But what if the company has gone one step ahead? That means they reserved the name by furnishing incorrect particulars. Thereafter, the company was also formed. And now we get to know that, okay, the name was reserved by furnishing incorrect information. Then what will happen? They will give you an opportunity of being heard, and they can pass any relevant order. They can ask the company, okay, change your name within 3 months, or they can strike off the name, or they can also submit a petition for winding up, that no, just wind up this company, whatever liabilities are there, pay them off, and close down this company. Okay, so this order may also be passed. Okay, so this is basically the first step in the process of incorporation, which is name reservation. Name reservation, right? Second step is about filing of documents. Now, why have I come over here? Section 7 tells us the entire procedure about incorporation of a company. It tells us that you need to prepare certain documents and give it to ROC, and ROC will issue you a certificate of incorporation, right? So the first thing that you did is you have to fill Spice Plus form. Spice Plus form, part A you have filled, you have reserved your name. The name reserved is for, in general, a period of 20 days, which can be extended up to 60 days, right? By giving, of course, additional fee. Now, the second step is you're preparing all the documents. The first document that is needed is Memorandum of Association. The question comes, what is Memorandum of Association? It is given in section 4. Okay, it's given in section 4. What is memorandum? So memorandum, the definition is given in section 2 clause 56, which actually tells us nothing. It basically tells us memorandum means memorandum as originally framed or as altered from time to time. Okay. Now, what is it? It is the basic document of any company. It tells us about the company. What is the name of the company? Where is the company? What does this company do? What this company can do? Who has formed the company? Right? Everything, basics about the company. That means first, name clause. If it is a private company, it will be written like Shivangi Private Limited. If it's a public company, it will be like Shivangi Limited. If it's OPC, there will be OPC in bracket, right? So we have read suffix about all the different types of companies, and that's how adding suffix and the name is being written, right? The next is situation clause. Situation clause does not mean you need to write the entire address of the company. No. You only need to tell us the state in which this company is situated. So only the state. Third is object clause. Object is what? The purpose for which company is being formed. It actually tells us the scope and purview. That okay, company can do these many things. Company can't do beyond this. So these are the 4 things which are written. Company can do only these 4 things. If the company does anything outside this, it is going to be violation, right? Because we have a doctrine of ultra vires, right? Okay. Next is liability clause. Liability clause basically tells us whether the liability of the company is limited or unlimited, because an unlimited company can also be formed. So the liability of the company, the liability of the members of the company is limited. First thing, limited by shares, limited by guarantee, right? So that is what they are going to write. Next is capital clause. Capital clause, we have different types of capitals about which we'll read in the chapter of share capital. But right now we have registered or authorized share capital with the division. Division means there will be 1,000 shares at the rate of 10 each. So 10,000. That is how it is being written. And succession clause only in case of OPC, where you write the name of nominee. Okay. Now, when I'm talking about Memorandum of Association, we basically have 7 schedules under Companies Act. In that, Schedule 1 tells us about all the formats of Memorandum of Association and the model articles. So if I am a company which is limited by shares, then what I can do is I can, as it is pick up table A, right? So it has the format or pro forma of Memorandum of Association, and thereafter the name of the company is this. I have filled that particular information. The company, the liability of members of the company is whatever, right? So that is how it is. So respective forms are there in Schedule 1. The memorandum of association has to be printed, signed, divided into different paragraphs. It has to be prepared by every company. It's required at the time of registration, and later on it can also be changed or altered according to section 13. So we have section 13, which talks about alteration of memorandum. Very important section from examination perspective, right? Okay. Then we have articles of association, which is basically given in section 5. What is articles? Articles are the internal rules of the company, that how the company is going to run, right? Like if a shareholder does not pay call money, what is the procedure? How we will forfeit his shares? You have read about forfeiture in accounts also, right? So how will we forfeit his shares? So that is given in articles of association. So a lot of powers, a lot of internal things are actually given in the articles of the company, which are company specific. Of course, within the powers which are conferred under the act, you cannot do anything beyond that. But within that, you can always state, okay, my company can do this, my company cannot do this, right? So that are internal rules and regulations. Of course, they are given in respective tables. There are model articles which you can adopt as it is, or you can strike them off. You can change any clause. You can do whatever you want to, right? Again, the same thing, it can be later on altered also. There is one special thing in articles of association, and that is called as entrenchment provision. Section 5, entrenchment. What is entrenchment? Entrenchment means basically making something more difficult. If I take you through section 14, which is alteration of articles of association, it tells us you have different clauses of articles of association, and if you want to change any clause, basically you can do that by passing special resolution. What is special resolution? Special resolution means we call the members, we ask them, and if 3/4 members agree, 3/4 majority has to be obtained, right? So if there are 100 members who are actually voting, who have actually voted, there should be at least 75 members who say yes. Then SR is passed, otherwise SR is lost, right? So this is SR. And we need SR to alter every clause of articles, right? Supposedly in one clause we have written that Shivangi is going to be the MD for life. Now I know that, okay, I am ready, I agree to put in all that efforts, considering the fact that they have written in the articles that I'm going to be the MD for life. But what if tomorrow they change it by passing SR? So I'm a little concerned. I say, no, I want to add entrenchment. Before I agree to this, I want to add entrenchment. That means I am saying that changing this particular clause make it more difficult. How can you make it more difficult? There can be ample of ways. One such example, that this particular clause will be changed when members or when I get 90% majority. When I get 90% majority. So this is adding entrenchment to articles of association. Now, entrenchment can be added at the time of formation. Of course, whoever agrees to this, who will actually subscribe, otherwise they'll not subscribe. So you don't need to obtain anyone's permission, right? Otherwise, later on, if you're adding some entrenchment, the existing members might say, no, this was never decided, this is not happening, right? So if you want to later on add this entrenchment, then in a private company, you need to ask all the members, and if they all agree, then only you can add entrenchment. And in case of public company, you need to pass SR. Okay, fine. So I think this is clear. Okay. Now, there is one more section 3A before we actually go on to the process of incorporation. What is section 3A? Section 3A tells us members severally liable in certain cases. As we read in section 3, you need to have minimum 2 members in case of private company. You need to have minimum 7 members in case of public company. And this is not just required at the time of incorporation, but throughout the lifetime of the company, right? But supposedly I started the company with 7 members and I formed a public company. One fine day, or I shouldn't call it a fine day, one bad day, 2 of the members met with an accident and died on spot. Now, how many members are left? There are 5 members left, right? Out of these 5 members, there are 2 members who are in abroad, right? Somewhere enjoying their holidays and everything. So we have 3 members here in India who knew about the accident and who now know that, okay, we are just 5 members remaining. What should they do? Should they continue the company with 5 members? Okay, I started with 7 members. What if 2 members died? No, they cannot do that. Law says that you need to find 2 more members and make it 7, because that is the statutory minimum. Statute says minimum number of members has to be 7, right? So that is the statutory minimum and you must comply with that. But of course, law understands that you cannot comply it in one day. So you need a span of some days, right? So the law has given you a span of 6 months. Okay, go ahead and comply with it. Go find out the members. But if you carry on the business after 6 months also with the reduced member, then every member who knew this fact that, okay, we are less than 7 members and you're still doing business, then those members are going to be severally liable for the debts of the company which you contracted after 6 months. Clear? So that is section 3A. Fine. So I hope you have understood memorandum and articles also, and the first step of incorporation. Moving to the next step. So you have reserved your name and now you are preparing all the documents, right? What documents are needed? I have already told you about the basic document. What is the basic document? It is memorandum and articles of the company. Now, memorandum or articles, they are going to be duly signed by the subscribers, right? How do they sign it? In the manner as prescribed. So that is the first basic document that you need. The second thing is a declaration. Declaration by whom? Declaration by anyone who is involved in the formation of the company. That is declaration by professional. It could be a chartered accountant, it could be a cost accountant, it could be a company secretary, it could be an advocate, right? Whoever is engaged in the formation of the company, right? And declaration by your director. In the articles, we write that this particular person is going to be the director of the company. So whoever is mentioned in the articles as the director or the manager, she also has to give that declaration. So 2 people are going to give the declaration, and this I call as a compliance declaration. What is a compliance declaration? That all the requirements have been met. All the requirements have been met. So first is memorandum, articles, declaration by CA, CMA, CS or advocate, and declaration by directors, right? That all the requirements have been complied with. The next is again a declaration, and this declaration is given by the subscribers and the directors. Subscribers and the directors. And in this declaration, they actually tell us that we have not done any offense, that we have not been ever found guilty in promotion, formation of the company or management of the company. We have never been found. Okay. Secondly, we have never been found guilty of any fraud relating to the company in the last 5 years. In the last 5 years. And whatever document we are submitting, they're all correct. They are all correct. Of course, the documents that we are submitting are correct to the best of my knowledge, to the best of their knowledge, right? So that is what the declaration they are going to give. So declaration of compliance by these 2, declaration of no offense by these 2, and thereafter the particulars of what? Particulars of office, that means the address of correspondence till the registered office established. So if a company has an existing registered office, great, you'll provide that address. If they do not have, then any correspondence address, still actually you find a registered office address for the company. Next is particulars of all the subscribers, particulars of all the directors, consent of directors. Okay, so all these documents are going to be compiled, are going to be attached in Spice Plus Part B, and thereafter you are going to submit it to ROC. You have to preserve all these documents till dissolution. ROC will issue you a certificate of incorporation in INC 11. and allot you a corporate identity number, that is SIN. Fine. I hope so far the things are clear. You should also know about ultra wires. What is ultra wires? The basic things I've already told you. There is a case of Ashbury Railway Company, which we'll read a little later. Okay, fine. Now, there is section 9. What does section 9 tells us? Okay, one more thing which I want you all to remember. There are certain details about signing, because I told you have to make memorandum of association and articles of association and get it signed in the prescribed manner, right? So there are basic some rules of signing. They are going to be signed by every subscriber. Okay, and when you sign it, you are going to write what is your name, what is your address, what is your occupation. Okay, and then there will be a witness who will attest the signature of the subscriber. Okay, that is clear. Now, supposedly the subscriber is illiterate and he cannot sign, then what will happen? It's a basic thing that he will affix his thumb impression, and the witness will authenticate that, right? So that is going to be happening. Supposedly there is a subscriber who is a body corporate, so of course he cannot sign. Then in such a case, who will sign? Then there will be any director or officer of the company who will be authorized to sign. Then that particular person will sign. Supposedly the subscriber is LLP, then who will sign? The partner of LLP will sign. Okay, supposedly the subscriber is some foreign national who does not reside in India, then we also have to comply with the Hague Apostle Convention, right? If you're not a part of it, right? So you have to remember all those basic details. If I am talking about here, ma'am, there has to be some subscriber details. Then what do we need about the subscriber details? Your personal details like your address, your email, your ID proof, your residential proof, your proof of nationality. If you are a body corporate, then we also need your SIN, right? So basic details are required. If you are a LLP, then your copy of resolution that you have, that all the partners have agreed by, right? Okay, then particulars of first directors, against the same thing. You also need DIN in case of first directors. Fine. So these are some intricate details which are also required to be learned by all of you. Please don't think that you can skip this particular part, right? Now, if later on it is found, just like we studied that if later on it is found that you have reserved the name by furnishing incorrect information, there's a penalty. Likewise, if later on it is found that you have incorporated the company by furnishing some incorrect information, then again there could be two situations. While screening the application, it is being found and the company is not yet formed, then whoever was responsible will be liable for section 447, that is a universal section under Companies Act for fraud, about which we read in the chapter of prospectus, right? Secondly, if the company is formed and the promoters, first directors, subscribers, they are going to be liable under section 447, and there will be additional orders. Additional orders like what? If an application is made to tribunal, what tribunal can pass order like? Okay, this particular management from the very beginning, they are involved in fraud. They are submitting incorrect information for formation of the company. So we must regulate the management. So this order can be passed. Tribunal can also direct that, okay, the liability of the members was limited, but since they have done this, we'll make the liability of the members unlimited. Or they can remove the name from the register of the company. They can also wind up the company or pass any other order as they may deem fit. Okay, as they may deem fit, right? Okay. Then once the company is incorporated, the subscribers now become the members. The subscribers now become the members of the company, right? Okay, give me one sec. Section 6 tells us that Act is going to override the memorandum and article. So whatever is given in the Act, is going to be supreme. And if you write anything in memorandum, or if you write anything in articles, or if you pass any resolution, if you make any agreement, and that particular point contradicts the act, you have to keep in mind that always act is going to be superior, right? So if I try to recall the entire procedure, what is happening is, there's a promoter, he applies for name reservation, he prepares the documents, application, MOA, AOA, declaration of compliance, declaration of no offense, particulars of registered office, particulars of subscribers, first directors, right? And everyone, he files those documents with ROC, and ROC allots you a certificate of incorporation, right? So I think so far the things are clear. Okay. The other details also need to be remembered, right? Yes, ma'am. Okay. This also I've told you. Right. Next section that we can see on screen is section 10A. But before that, we also have section 10, which actually tells us about the effect of memorandum and articles. That once your memorandum is submitted to ROC, along with the incorporation documents, everything, once your articles are submitted to the document, they have registered your documents, then it is going to bind the company to the members and the members to the company. Right, they're bound by each other. It does not bind the company to the third parties, but otherwise it is going to bind the members and the company. So whatever is written in those articles, you have to comply with it. Whatever is written in those in that memorandum, you have to comply with it, right? Next is section 10A, which talks about commencement of business. See, earlier this section did not exist, and therefore whatever company was incorporated, it could immediately start its business, but now that is not possible. Now what happens is, this is basically nothing. Earlier this used to happen. Now what happens is, if you are a company without share capital, you can start your business immediately. That's not a problem. But if you are a company with share capital, you need to ensure certain compliances. One, you are a company with share capital, right? So there would be subscribers to the memorandum who have agreed to contribute some amount to the share capital. Like, let's say there are 4 friends who have formed a private company. They all have said that, okay, I'm going to give 50,000 and I'll get 500 shares at the rate of 100 each, right? So that is what they have said to the company. Now, once the company is incorporated, they will contribute whatever amount they have said, and the company in turn is going to issue them shares. This should happen because it is a company with share capital. It is mandatory for them to invest what they had agreed to, right? So the company has to file INC 20A within 180 days of incorporation. What is this? This is nothing but a declaration by the director that yes, the subscriber has paid the agreed amount. Plus file INC 22. What is INC 22? It is about the registered office. Supposedly the company started with the correspondence office. Now it will have a registered office because it need to have registered office from 30th day of incorporation. Earlier it was 15th day, now it's 30th day only, right? So once your company is registered, within 30 days you need to find a registered office, and from that day onwards till the dissolution you must have a registered office at all times. So you need to give those details also, right? And thereafter you can commence business. There is penalty for non-compliance of provisions, and if without filing such declaration you're doing business, and then ROC can come and they can inspect, and if they believe that there is no business, they can also remove your name from the register of members. Okay, then we have section 12. What is section 12? Section 12 talks about registered office, publication of name, everything. So first, your registered office cannot be a PO box. It is very different from corporate office or head office. You need this particular registered office because all the documents, notices are served here only, and based on where your registered office is situated, it determines your domicile of the company, right? So company within 30 days of incorporation must have a registered office, and you must furnish this to ROC within a period of 30 days from incorporation, right? First thing. Secondly, every company, doesn't matter you have a small branch, you have a big branch, you must affix the name of the company and the registered address outside every office, in proper legible characters, which can be read, right? It has to be in local language also, if that is a language which is used generally in that particular locality. Like I have always given you an example of Bengaluru, that's my favorite, right? Okay. So I think that is clear. Now, if registrar has a reasonable cause to believe that, okay, you have opened the office, but you're not doing any business from this particular office, they can come and they can physically inspect that particular place, and thereafter they can also initiate removal of name of the company. Okay, fine. We have certain things about one person company, right? What is one person company? We all know that. So who can incorporate a one person company? Natural person, Indian citizen, whether resident or not. You don't need to be a resident of India to form a one person company or to become its nominee. Even if you're not a resident, you can still form one person company, you can still be the nominee of that one person company. Okay, first thing. Now, what additional things are there when you're forming a one person company? Then additional things are about finding a nominee and obtaining his consent, right? Okay, so along with the documents MOA, AOA, the compliance declaration as to no offense, particulars of directors, of subscriber, right? We have one subscriber only, director's consent, address, everything. You also need to furnish the consent of nominee when you are incorporating a one person company, right? So that is the simple thing. Now, what different we have is that if you have given a name of one nominee, can it be changed? Supposedly you did not like that particular nominee. Yes, it can definitely be changed. See, first of all, there could be a nominee who can withdraw his own consent, right? So what will happen in this particular situation? He or she is withdrawing a consent by giving notice to the sole member, right? Now the sole member will nominate another person as nominee within 15 days from the receipt of the withdrawal, right? And they are going to notify that to ROC, and that particular person will be written as nominee. There could be a situation that you are replacing nominee with another person, right? So if there is any such change, we have INC 4, and within 30 days you can do that, right? Then there could be third situation when the nominee is actually becoming the member because of the death of the sole member. So if the nominee becomes the member, he is going to nominate another person within 15 days. So when he becomes the member, he's going to nominate somebody within 15 days. Okay, so that is what actually happens. Fine. Okay. Now, one person cannot be a member in more than one OPC, but can be a nominee in one company. If he becomes member in two, he is going to choose within 180 days. So at one point of time, you can be a member of one OPC and a nominee of another OPC. You cannot be a nominee of two OPCs. You cannot be a member of two OPCs, but you can be a member of one OPC and a nominee of one OPC. Supposedly, where you are nominee, that sole member dies and you become the member. Now at one point of time, you're a member of this OPC also and you're a member of this OPC also. So you have to choose which OPC you want to continue as a member, right? There are a lot of exemption benefits which OPC gets, right? You don't have to prepare cash flow. You have an abridged return, right? Annual return, which we talk about in section 92, right? There are easy signing provisions. We talk about financial statements of OPC. It has to be just signed by one director, right? There is a board's report. You don't have to prepare that elaborate board report. Your board's report is going to be a abridged one, right? You're not required to hold annual general meeting because who you will meet with? OPC is a company with just one member, so you're not going to meet with your own self, so no requirement to hold AGM, right? Then no requirement or you can say relaxation in case of board meetings also, and in case of filing of financial statements also. You are not supposed to file the financial statements within 30 days from AGM, right? What is it? Within 6 months from the close of financial year. So you have different provisions, right? Okay. So I think this is clear. Moving to the next part. If I talk about conversion, OPC can definitely convert itself. See, voluntary conversion is there. Compulsory conversion of OPC has been deleted long back. Okay, so compulsory, voluntary conversion, of course, OPC can convert itself into private or public company by altering the memorandum and articles. And all you have to do is file an application with ROC. If ROC is satisfied, they'll approve and grant you the certificate. So nothing very special. You have to comply with all the requirements. If you're converting into a private company, comply their requirements. If you're converting into a public company, comply with their requirements. And you can do that. That is not a problem. Okay. Then moving to the next part, that is Section 8 company. What is Section 8 company? We all know that it is a company which has been formed for charitable purpose, right? So what are the eligible objects of such type of company? You can promote environment, you can promote charity, you can promote commerce, you can promote science, education, research, sports, a lot of things, right? Okay. Now, can Section 8 company be formed as OPC? The answer is no. See, there are only 3 ways how you can form a company. It could be private, it could be public, or it could be OPC. So when you're forming a Section 8 company, or when you're forming a government company, you can form the company as private or public, right? So if you are forming a Section 8 company, you could form the company as a private company or as a public company. It doesn't matter. It is as good as a private or a public company. The only difference is that because it is a company which is doing a lot of charity, right, and its motive is not to earn profit but the welfare of society, it gets a lot of grants, it gets a lot of benefits, exemption benefits under Companies Act, under Income Tax Act. It gets a lot of subsidies, grants, donations, etc., etc., right? So because it is conferred with a lot of advantages, you cannot start a company just like this, right? Because we all know that India is full of corruption, right? So basic checks. You need to obtain license from central government, right? So license from CG is needed. Now earlier there was a whole system that you need to obtain the license, then you need to apply for the incorporation. Now we have the license obtaining information or application incorporated within the application of incorporation. Okay, so you fill Spice Plus, therein only you provide some additional details which actually helps you get the license as well as COI. Okay, so if there is any person who wants to form a Section 8 company, right, maybe a private Section 8 company or maybe a public Section 8 company, you don't need to add limited or private limited at the end of your name, but what you can do is you can fill Spice Plus and submit it. What is going to be the attachment? Of course, there is going to be memorandum of association, there is going to be articles of association, there is going to be that compliance declaration, right? Apart from that, there is going to be an estimated income and expenditure account for the next 3 years. Okay. For grant of license, you know that. And declaration of by every person, whoever is making an application. Okay. So once you submit all these applications, ROC is going to issue a certificate of incorporation. Now, if license has been given, this license can also be revoked. Who has the power to grant license? ROC has basically the power has been delegated. That's why I'm saying ROC. You please remember central government only for your exams. Now, the granted license can be revoked. Supposedly, the license was given to you and there were some additional conditions also told to you that, okay, we are giving you the license, but you have to comply with these 4 conditions. You have to comply with Section 8, plus you have to comply with these 4 conditions. You did not comply with Section 8, license can be taken back. You did not comply with the conditions which were stated, license can be taken back. You are doing some fraudulent conduct, license will be taken back. You are violating your objects. You're not doing any fraud, but you are not supposed to do this thing, because your object clause clearly stated that you can promote sports, but you're doing something else. Maybe that's not fraud, maybe that's not some improper conduct, but you're violating the objects, right? Or you're conducting affairs against public interest. Supposedly you're doing something in the name of religion, but that's creating a not so harmonious environment, right? It's somehow instigating the riots and all that, right? So that's against public interest. So again, license can be revoked. Okay, so in all these situations, license can be revoked, and central government will direct that, okay, change your name. That means if you're a private company, add private to your name, and it may also pass additional orders like winding up if necessary in public interest. Here you need to understand one thing. What is that one thing you need to understand? Is that whenever a Section 8 company is being shut down like this, then you have to understand that winding up order may be passed. Winding up order may be passed is like whatever assets are there, sell off those assets, pay off the liabilities, whatever excess assets are remaining that are not going to go in the pockets of the members. Rather, it will be transferred to another company which has the similar objects. Okay. Secondly, the entire company may be sold, and the whatever sale proceeds are there, it will be transferred to IBC fund, right? Or there may be an order of amalgamation in public interest that, okay, let this company be amalgamated with this particular existing another Section 8 company, right? So that can also happen, right? Then we have certain provisions. Just a second. Right. Then we have certain provisions with respect to conversion of Section 8 company. Okay. Now, if you want to convert Section 8 company, the first basic requirement is that you must have had filed your financial statements and annual returns. Okay. If you want to convert Section 8 company, then there will be a notice which will be sent to the members, because you need SR. So first you will send notice to the members. Notice will be accompanied by explanatory statement that you send to the members. There is general meeting of the members, and in that general meeting you pass SR. That is the first thing. Okay, that is the first thing. So if you are converting Section 8 company into any other company, you need SR at general meeting. The next thing is that you need approval from regional director, right? So you will also make an application to RD, right? And you will give a copy of it to registrar. You have to attach a lot of things. You have to attach the proof that you have given it to the authorities, also what representation you have got from the authorities, right? And that is what you'll get. So you file an application to them also and a copy to registrar. Now within 1 week, you publish a notice in INC 19. That is a notice which is published in the newspaper, vernacular newspaper, English newspaper, and also the website of the company, right? So that everyone gets to know and they can raise objections if they want to. Okay. Right. So RD is going to issue order approving conversion, and thereafter company will call general meeting, pass SR, amend MOA and AOA, file it with ROC, and ROC will issue a new certificate of incorporation. So this is what actually is the entire process of conversion of Section 8 companies, right? Section 8 companies also have a lot of benefits, that if you want to call the meeting, general meeting has to be called by given 21 days notice. But here you have to give only 14 days notice, right? They don't have any requirement of minimum number of directors. Otherwise, you have the requirement of minimum number of directors, that in a public company, there must be at least 3 directors. Here you don't have that requirement, right? They don't need to form those committees, nomination and remuneration committee and all like that, right? Okay, so I hope this is clear. Fine. Moving on to the next part. Alteration of memorandum. Alteration of memorandum is given in Section 13, right? Whenever you want to alter the memorandum, it has to be altered by passing special resolution. First is name change. So if a company wants to change its name, can it do so? The answer is yes. How can it do so? By passing SR. Plus, you need CG's approval. So if you want to change the name of the company, you need CG's approval. However, if you're just converting a private company into public company, you're not exactly changing the name. But supposedly the company's name is ABC Private Limited. You're making it a public company. So you will what do? Delete this private and the name of the company now will be ABC Limited. So for this, you don't need CG's approval. Okay, for this, you don't need CG's approval. You can change the name of the company only if you have not defaulted in filing your financial statements or annual returns, or you have not defaulted and you have not defaulted in repayment of deposits, debentures, interest. If you have defaulted in that, then rectify that default, right? You cannot change it. Okay. Fine. So we have two things. This is about voluntary name change, which is actually given in section 13, And this is the procedure that I have already told you, that you make an application to CG, and once CG gives you an approval, you intimate the same to ROC that yes, my members have approved by passing SR and I have also got CG's approval. You register my new name and issue me a new certificate of incorporation, right? Okay, so that is about name change. Okay, so registrar is going to enter the new name and in place of the old one, issue you a new certificate of incorporation. Fine. We will come to this a little later. First, we will complete all the alteration of memorandum, right? The second one is situation clause. Alteration of situation clause. Now, when I'm talking alteration of situation clause, it basically means that you are shifting your registered office from one state to another. Because if you're shifting it within the same city, it does not amount to alteration of memorandum at all. If you're shifting it from one state to another, then that is going to be alteration of memorandum, right? And for this, you need again CG's approval. So you make an application, you need SR for sure. Okay, you need SR for sure, right? So you have passed SR. No problem at all. Here, what you need to remember is that central government gets an application for change of registered office, right? Now, before approving, they will satisfy that you have creditors, you have debenture holders, you have other people, right? Have you made sufficient provision for their discharge of obligations, or you have provided them the adequate security? See, you could have done three things: pay their debts, make sufficient provision for their debts, or provide them adequate security. If you have not done this, CG is not going to grant you approval to shift your registered office from one state to another, right? Okay, so CG is going to satisfy that, right? There is an entire detailed procedure which has also been given, but you have to remember what I am telling you. Okay, so once you get CG's approval, I'll just come back. Once you get CG's approval, you have SR, you have CG's approval, right? You file this with both the states, right? So you file it with the registrar of the old state as well as the registrar of the new state, right? The registrar of the new state will actually give you or issue you a fresh certificate of incorporation, right? The third is change in object of the company. Change in object clause. Again, the object clause can be changed by simply passing SR. However, if you are a company, you issued prospectus, you raised funds from public. Supposedly, you have raised 1 crore rupees from public saying that I will do this and this. But now you're not going to do this. Now you're changing the objects and doing this. So you have taken their 1 crore rupees. They wanted you to invest in this and that's why they have given you the money. But now you're doing something else, right? So if you have raised funds from public, and out of that 1 crore, you still have 10 lakhs remaining. That means you have raised funds from public and you still have unutilized money. You cannot change your objects just like this, just by passing SR. No, you have to pass SR through postal ballot. Okay, and how it will be done? The resolution is going to be published in the newspaper, English as well as vernacular, right? Wherever registered office is situated, it will also be placed on the website, and any shareholder, if he dissents, he will get an opportunity to exist. How he will get an opportunity? As according to SEBI regulations. Fine, so he'll get an opportunity to exit. That means if he doesn't want to continue, you will repay him. Okay, so this is going to happen. Fine. Once this approval is accorded, then you will intimate to ROC, and ROC is going to give you that, is going to certify that, right? And every alteration has to be noted, has to be registered. If you are just doing alteration in your own paper and not actually registering it with ROC, then it does not make any sense. It is not going to have any effect. Clear? Okay. So these alterations only we basically discuss. We don't discuss about alteration of capital clause or liability clause. Basically, we read in the chapter of share capital. Fine. Okay. Now, apart from that, we have certain other cases also where there may be change in the name, where there may be change in the registered office, right? So one name change is given in section number 16, which actually talks about rectification of name. So here you don't want to voluntarily change the name of your company, but you're forced to change the name of the company. Why? Because somehow the company got registered with an identical name. Although this does not happen when computer is at work, right? Now it's all AI. So this situation does not come across, but it may happen, right? So in such a situation, central government would direct the company that change your name within 3 months. And once you get that direction within 15 days, you have to intimate ROC with CG order, reserve a new name, and ROC will issue you a new certificate of incorporation. If you fail to do so, central government will issue you a new name, and thereafter you can voluntarily change your name if you want to. Okay. Second case, if there is a registered trademark, okay, like book my video, let's say, right? So it is a registered trademark, and there is somebody who formed a company with Book My Video Private Limited. Now I might have an objection because I already have a brand name in this particular thing, right? So I raised an objection within 3 years of their incorporation. Okay, I have made an objection to ROC, and ROC is now what going to do? Central government works through ROC only. So central government is going to direct that particular company that no, change your name within 3 months, and the same entire process is going to follow. Okay. Secondly, if I want to change my registered office from one city to another, all I need to do is pass board resolution. From one city to different city within the same ROC, pass SR. That's it, right? From one ROC to another ROC within the same state, I need to get the permission of RD, and this I have already told you, right? Alteration to object clause also I have told you. Next is alteration of articles. Section 14 tells us about the alteration of articles. Again, it is something which can be passed or which can be done by simply passing SR. Okay, simply passing SR. If I want to convert private company to public company, I will pass SR. SR plus altered copy of altered articles of association I will submit to ROC. Clear? But if I am converting my public company to private company, see, public company is exposed to a lot of compliances. It has to disclose this, disclose that, right? It has taken funds from public. A lot of things might be there. Now it is trying to convert itself into a private company. So government will be like, wait, let me check. Right? So in this situation, you also need to obtain approval from CG. So SR needs to be passed. There will be approval from CG, and your altered articles of association, you will submit it all to ROC. This I've already told you. Right? You will submit it all to ROC. right? We have section 15, which tells us that every alteration that you have made in memorandum or articles has to be noted in every copy of memorandum of or articles. If you actually circulate any unaltered copy, then there is going to be penalty of 1000 for every copy, right? Okay, there is section number 17 basically, which tells us that if any member wants a copy of memorandum or articles, you have to provide them within 7 days of request. Okay, fine. Then we have section 19, which talks about subsidiary and holding. That subsidiary company cannot hold shares in its holding company, right? It's going to be like a vicious circle, right? So it is not allowed. However, there are certain exceptions. What are the exceptions? Exception number 1. If I am a subsidiary company, or let's say we have A Limited holds 10% shares in B Limited. Okay. Then B Limited acquired 57% shares in A Limited. That means A Limited is holding these 10% even before it became the subsidiary, right? So where the subsidiary company is a shareholder even before it became the subsidiary company, then that falls under an exception and it is allowed, right? Secondly, subsidiary company is holding the shares as a legal representative. Supposedly there's a deceased member and who has made this particular company as a legal representative, so it is not holding the shares in its own capacity, right? Or maybe it's holding the shares as a trustee. Okay, so these could be the situations. In these two cases you will get the right to vote, but in this case you will not get the right to vote. Okay, fine. Then we have section 20. Section 20 basically talks about the service of documents, that whatever document you want to send to the company or you want to send it to some officer, how you can do that. Registered post, speed post, courier, leave it at the registered office, or any electronic mode or any other mode as may be prescribed. So that is something which is allowed. Fine. If you want to send to the member or ROC, post or registered post, speed post, courier, leaving at the office, electronic or any other mode as may be prescribed. The only difference is here post is not there. Okay, fine. These are some very basic detail, some very intricate details. Section 21, that if there is any authentication which has to be made, it is going to be made by KMP or any officer who is authorized. Then we have section 22, which talks about execution of bills of exchange. So if the company has to prepare a check or has to prepare a promissory note, right, whatever it is, then he may authorize somebody. If the company is having common seal, yes, in writing it may authorize any person as attorney in or outside India. If there is no common seal, then authorization shall be made by 2 directors, or where company has company secretary, by director plus 1 company secretary. Clear? Okay. Then we basically have, just a second. Next, we are going to revise the chapter of prospectus and allotment of securities, right? If we talk from the Classification of Companies Act, it is chapter 3 and it comprises of sections 23 to 42. Right. Basically, this particular chapter is divided into 2 parts. The first part talks about public offer and the second part talks about private placement. Right. So, beginning with section number 23. Right. The very first section of this particular chapter talks about how can securities be issued. If we are talking about a private company can issue securities by way of private placement, which we talk about in section 42 part 2, right? Secondly, it can issue securities by way of rights or bonus, right? Both of which we read in the chapter of share capital, right? So we have rights issue, section 62, followed by section 63, right? So we have rights, bonus, and everything that we read over there. Okay. If I talk about a public company can definitely issue securities by way of private placement, rights, bonus, and it can also issue securities to public through prospectus by complying this part 1 of chapter 3, which is all about public offer, right? So if I'm talking about making a public offer, if there's a private company and it wants to raise funds by issuing securities could mean equity shares, it could mean debentures, bonds, whatever we are talking about, right? Securities is a wide term. So a private company wants to raise funds by issuing securities, it can do so only by private placement or rights or bonus, right? Bonus is simply capitalization of profits. It's nothing, you're not taking anything from people, but you're just capitalizing your profits and issuing them additional securities. However, when we're talking about rights issue is you are issuing securities to your existing shareholders, right? So you're giving a preferential right kind of thing, right? You're giving a right to your existing shareholders that I am in more need of money. So I want to issue 100 more shares. Are you ready to buy it? So you're giving an offer to your existing shareholders. If they accept it, great. If they don't, then we have the further procedure, how to approach, right? So a private company can do only that. But when we're talking about a public company, because private companies are prohibited to make public offer, right, to subscribe to their securities, but a public company can do so. So public company, if you want to make a public offer, if you want to raise funds by issuing securities to public, then you have to comply with part 1 of chapter 3. Part 1 of chapter 3, which talks completely about public offer. What are the different types of public offer that we have? IPO is when a company makes an offer for the first time. Initial public offer. FPO is further public offer. So if you've already made a public offer and you're making a public offer again, that is FPO. And there is something called as offer for sale. Offer for sale is a public offer of existing securities that we'll talk about. Okay. So all this is done by issuing prospectus. There are certain cases where prospectus is not needed. I'll exactly tell you what prospectus is. We're here to revise the entire thing, right? So you have to comply with part 1. Along with that, you also have to comply with SEBI Act and regulations in case of listed companies. Of course, any company which is making a public offer will be a listed company for sure. Because whenever you want to make a public offer, the first requirement is to make an application for in principle approval of listing to any stock exchange that you want to. Unless you get that approval, you cannot proceed with a public offer. So if your approval is denied, there is no way that you can go ahead with the public offer, right? So every company who has made a public offer will definitely be a listed company. Okay, fine. So we'll talk about the related section. Securities, you don't need to. Now, what do we mean by prospectus? See, prospectus ideally is defined in section 2 clause 70, which simply says that any document, let it be red herring prospectus, let it be shelf prospectus, let it just be an advertisement, a circular, a notice, which is actually inviting public. Okay, then see, prospectus is basically not an offer. It is an invitation to offer. Why it is not an offer? Because supposedly there is a company which has issued prospectus that the company wants to issue securities, 1 lakh securities at the rate of 10 each. Okay, let me be very practical and make you understand in the situation of the practical world. There are so many IPOs which come, right? We have this company's IPOs coming, etc., and we are applying for the IPO, but not everyone gets the IPO. Right? Some people get did you get that IPO? Oh, no, the company didn't allot it to me, right? So if it was an offer, if I applied for the security, if I applied for that share, if I applied for IPO, that would be an acceptance and that would amount to a promise. But no, it is not so. That is an invitation to offer. Then I, by applying to that IPO, is making an offer, and the company, if accepts or allots, that is acceptance of offer, and then that becomes a binding promise, right? That's how it's actually happening. Now, right. So basically, we have a beautiful section number 26, where we talk about the prospectus. Okay, there are a lot of things which are given for prospectus. Earlier, the section used to be very long. Now it's not that long, but still we have a lot of content to be read, right? Prospectus is actually needed to help the investors take an informed decision. Why? Because it will have so many details which are mandated by law, that if you're raising funds from public, they are gullible investors. They might not be knowing, they might not be aware of the entire happenings, everything, right? Because even if I talk that, okay, I am going to invest, I might be knowing certain things about a certain company, but might not know certain things about a certain company, right? And I believe I should be highlighted with at least the basics, right? So that is why law has mandated certain things, that if you want to raise funds from public, you must give them an offer document, which should contain these details, at least this information, that if you're raising fund from them, you should tell them what you're going to do, right? Who is behind you? Who is the promoter? There's a lot of things. Where have you got the approval? Where will listing be done? So there are a lot of details which are required to be inculcated in the prospectus. If the question is asked, what details are there to be stated in the prospectus, then we have section 26, which states the matters, and it clearly says, okay, let's move further. Let's move further. Okay, I will first take you through that. Yes, here is section number 26. Fine. So the first thing that it tells us, that every prospectus is going to be dated. So there must be date on the prospectus, because prospectus also has a life. What is the life? The prospectus is going to be valid 90 days after a copy is delivered to registrar. So once you have prepared the prospectus, you also deliver a copy to registrar. Earlier there was mandatory registration, now it's simply filing. So you give the copy to registrar, they keep in their records, and now whatever prospectus is dated, then it has a shelf life, or it has a validity of 90 days only, because after 90 days a lot of events, a lot of information which you have written, and that will tend to change, because the scenario has changed, because maybe the financials have also changed, maybe the company is now running into losses, and the people who are actually investing in the company need to know that, right? Okay. Now, every prospectus which is issued is going to be dated, is going to be signed. It is going to contain the information as specified by SEBI in consultation with CG. As specified by SEBI in consultation with CG. Now, there is another thing which is written, that SEBI, until specifies such information, whatever regulation SEBI has made under SEBI Act in respect of such information shall apply. So now, to know what should be written in prospectus, we actually need to go through the regulations which have been made under SEBI Act. We are not getting the information here under Companies Act, because under Companies Act, SEBI with consultation to CG has not prescribed anything. But under SEBI Act, therein they have made the regulations, and those regulations specify that what information and what reports must be given in the prospectus. Okay. Now, apart from this, there is also going to be a declaration. Okay, a declaration of compliance and a statement that whatever we have written in the prospectus, there is nothing contrary to SCRA and SEBI and rules. SCRA is what? Securities Contract Regulation Act, and SEBI, you very well know, Securities and Exchange Board of India Act, right? So there is nothing in contravention to these acts as well as the rules, right? So this is going to be written. This is going to be written as the content. Okay. Apart from that, there is an expert statement. Expert statement may be included in the prospectus, but it will not be included if he is not engaged. not to be included unless he's not engaged in formation, he has given his consent and not withdrawn it. Above points are mentioned in the prospectus. So one thing, he should not be a promoter, right? He should not be involved in the formation of the company. The second thing, he must have given the consent and he must not have withdrawn the consent. And third point, you must have written these things in the prospectus. So only then you can incorporate expert statement also in prospectus. Validity, I've already told you. There will be a clear disclosure on the cover page that a copy of prospectus is already filed with ROC and what documents are attached with the prospectus. So this is basically what is written in section number 26. If you do not comply with the provisions of section number 26, there is punishment for the same. Okay, fine. We come back. Now, if the company wants to raise funds from public through issue of prospectus, that is known as public offer, we have section 40. Section 40 tells us that whenever you want to make a public offer, what you should do is make an application to the desired stock exchanges for listing. If you have made an application to, let's say, 3 stock exchanges, you must get approval from all 3. If you have made an application to 1 stock exchange for listing, you must get approval from that, right? So rejection by even one of them will amount to complete rejection. Fine. So if permission is granted by all, then only you can proceed with. You have to prepare the prospectus. You have to include the name of stock exchange from where you have got in principle approval from listing. For listing, right? Thereafter, you will send it to ROC for filing. Within 90 days, you have to give the offer to public along with the application. You receive the application money. Nowadays, it's all, the money is blocked. People don't actually remit you the application money, but the money is blocked. If the share is allotted, the money will float to the company. If it is not allotted, then it will be released, right, by the bank itself to the customer, right, to the investor. Money collected to be kept in separate account. If minimum subscription is received, then allotment shall take place and you will refund excess money. Now money can be used, but no variation in terms of contract. However, if minimum subscription is not received, you will refund all the money. Now, one by one, we are going to read it in detail. We are going to read it in detail. But before that, what do we mean by variation of terms of contract? Because as I said, there is not going to be any variation on terms of contract. Where is variation? Okay, I'll go with the same sequence as I have written. I will not switch here and there. It will only create some confusion for you. Okay, so here till so far we have done. Let's begin with the allotment part, right? So we have first made an application to stock exchange for in principle approval. We have got the permission. We have filed the prospectus with ROC. Within 90 days, we are issuing it to public. That means the public offer is made, right? Okay. When we issue the same to public, right? We have a proper platform. When we issue the same to public, within 30 days, we must receive minimum subscription. What is minimum subscription, ma'am? Minimum subscription amount is basically 90% of whatever amount we need, right? Supposedly, we are raising funds of 1 crore. Then at least 90 lakh application we should receive. Now 90 lakh doesn't mean we are actually receiving 90 lakh but worth 90 lakh shares, right? If I'm raising securities worth rupees 1 crore, if I'm asking the people to buy securities worth 1 crore, maybe I will take the money in phases. That could also be the situation. Doesn't matter. But then whatever, and that is clearly stated in the prospectus. So minimum subscription amount will clearly be stated in the prospectus. Fine. So whatever amount is stated, you have to achieve that. No shares are going to be allotted to public until that minimum subscription amount is received. So of the entire issue, 90%, that is the minimum subscription amount. Now don't get confused with the application money, because there is also something called as minimum application money, right? Supposedly your share price is 100, right? Then a minimum application money has to be 5. Has to be 5. This is, let's say, face value. It has to be 5. This is according to section number 39. However, if I talk about SEBI regulation says 25% of the issue price. So let's say the issue price is 200. So it will be 50 according to SEBI regulations. Okay. So point number 1, minimum application money, whatever amount is payable on application should be at least 5% of the nominal amount according to this section and 25% of the issue price according to SEBI regulation. Second, unless you receive minimum subscription, you cannot proceed for allotment, right? Third, supposedly minimum subscription is not received. If minimum subscription is not received, people usually, now all the IPOs are oversubscribed, usually, right? But there was a time when this was a problem, this was a concern, that what would happen, the companies would want 1 crore and they got applications for only, let's say, 40 lakhs. So they took all the money, but then they could not meet their fund requirements, because to start that project, they needed 1 crore. Now they'll have to look for other ways to arrange those funds. And if the funds are not arranged, what happens is the funds collected are actually all turned into ashes, right? So for this particular reason, minimum subscription holds a very important place, right? Now, if it is not received, what will happen is you have to, within 15 days from the closure, you have to refund that amount to the same bank account. But yes, if it is received, we will go ahead and allot the securities and also file the return of allotment within 30 days. What is written in the return of allotment? To whom we are allotting the securities, contract of securities for issued for other than cash. See, sometimes it may also so happen that we are issuing somebody the securities because we have taken some asset from them, and in against those assets we are issuing securities, right? So in those cases, in those rare cases, because we file this return of allotment in all the cases, right? Even if it is public offer, even if it is not public offer, we have to file the return of allotment. So this also will be there. Okay. Registered valuer report for, these are not required in all the cases, but these are required in different cases. But when I'm talking about the return of allotment, the contents are all listed over here, right? Resolution in case of bonus shares, because when we're issuing bonus shares, a resolution is passed, right? So that resolution and all of that content is required. Okay, now we come back. We made an application to stock exchange. We got permission from stock exchange. We filed the prospectus with ROC. Within 90 days, we have issued the prospectus to public. The offer opens. Whatever money is received, that is kept in a separate bank account, right? That is an escrow account which is being opened. The offer closes. We have to check whether we have received minimum subscription or not. If we have received minimum subscription, we can go ahead with the allotment. But if we have not received minimum subscription, we have to refund the same. If money is not repaid, then there will be a liability to pay interest also. Okay. Once we have allotted the securities, then we will file a return of allotment to registrar within 30 days, right? There are attachments which needs to be attached along with the return of allotment. Okay. So you have to understand basically one thing, that whenever a company is making a public offer, it must issue prospectus, right? One thing. Prospectus must be filed with the registrar before you can make a public offer. You must get in principle approval of listing from the stock exchange before you make a public offer, and this fact must be stated in the prospectus also. You must receive minimum subscription, then only you can then only you can proceed for allotment. Your application money should not be less than 5% of the nominal value of security, right? After making allotment, you must also file return of allotment. Whatever money you have received as an application money should be kept as in a separate bank account. So all these are the basic requirements that we have read so far. Okay. Fine. Default, I've already told you. Not required. This is something that I've already told you. Right. Now comes the next thing, which is talking about misstatement. What is misstatement? See, misstatement could be hiding something which must be told, or it could also mean something untrue. untrue statement. So prospectus basically should disclose all the material facts which are likely to influence the decision of investors, right? Just a second. Right. Okay, that is, it must be free from misstatements. Now, basically, there are two important sections, section number 34 and section number 35, right? Section number 34 talks about criminal liability and section 35 talks about civil liability. Okay. Section 34, see, supposedly you are driving on a road and you, let's not talk about you, let's supposedly Mr. X is driving on a road and he met with an accident. Now, he was driving at a very high speed, so he has somehow violated a law for which he should be punished, right? That is, criminal liability is being attracted to him. At the same time, because of him, somebody else has suffered damages, so he must also compensate that person and give damages to that particular person. That is civil liability, because you're liable towards civil people because they have suffered some losses because of you, and the other is you have violated a law, so you are also liable criminally for a punishment. So that is exactly what the scenario is over here also. So if there is a prospectus which includes any untrue statement or any statement which is misleading, right, then every person who has authorized that issue of prospectus is going to be liable under section 447. What is section 447? Section 447 actually gives us the punishment for fraud, and it says that it has different I wouldn't suggest you to learn this, right? But of course, I have told you this, right? So there is a penalty and there is a punishment which has been given in detail about section 447, right? Now, if you prove that no, I had proper grounds to believe that this is true, and that is why I signed on this prospectus. I actually believe the statement to be true, because whenever we are vouching on any information, we always say to the best of my knowledge and belief. So I actually, if you can prove that you were innocent, you were not involved in the fraud, you actually at the time of prospectus you believe that it was true and this was not required, then you can always get the defense and you can be saved from that liability, you can be saved from that imprisonment, penalty and everything. Now, section 35 actually tells us that if there was a misstatement and on the basis of that misstatement somebody relied and he suffered some loss or damage, then the director, the person who has authorized himself or is named in the prospectus as director, who's promoter of the company, right, who is an expert, then they are going to be liable to pay damages to that person who has sustained loss. So the first prima facie requirement over here is loss. If there is no loss, then there is no section 35 which gets attracted. Again, if you can prove this, that no, I consented to be the director, but when I got to know about all these malified intentions, immediately I withdrew my consent. So if you can do that, if you can prove that, then you're not liable, right? If you can prove that this prospectus was issued without my consent, I didn't even know that my name is incorporated over there, and when I got to know this, I immediately gave a public notice, you are away from that liability, right? And the last point, with regard to every statement which is made by the expert. Now, sometimes what may so happen, if I have to take an opinion of a doctor, right? I believe that particular doctor to be competent enough and he gave this, and I went to some other person and told, look, this particular person is suffering from this and this is the medicine. So I have also conveyed the same to one of my employees that this is what we have got, right? Now, can they actually, if that prescription or if that diagnosis or if that medicine is found to be untrue, can they actually blame on me? Yes, they can, but I get that defense. No, that I completely relied on that doctor. The same goes over here also. If there is a valuation report, right? Now that valuation report, I have relied on that valuation report. I thought that the person who is making that report is competent to make it. That person had given his consent. That person had not withdrawn his consent, right? So I have signed on the basis of that only. If that report is found to be untrue, how am I responsible, right? Because I have incorporated a correct extract of that report, and that report is made by a competent expert person, right? So that is also a point of defense. Fine, that is also a point of defense. Fine. If I go on to the same league, we also have section 36. Where's section 36? Just a second. Okay. Section 36 actually talks about punishment for fraudulently inducing people to invest money. Sometimes we have a lot of people who are coming over and who are saying that no, this is a stock in which you must invest, and look, you will make it will be just you invest 50,000 and it will be 1 lakh in just 2 days, right? So anyone who is making any statement, any false promises, any forecast, right, any deceptive, misleading information, right, and trying to provoke, trying to induce the other person that no, you enter into this underwriting agreement, okay, or you acquire these securities, or you sell these securities, right, or you enter this into this this particular agreement where you are not going to sell the securities, you're not going to buy the securities, but you're going to get the profit, right, from the fluctuation of securities. So you're entering into an agreement that, okay, you're not buying, you're not selling, that is not your purpose, you're just enjoying. That is actually something which is not allowed. Fine. Or you are inducing someone to enter into an agreement for obtaining credit facilities from the bank, right? I have explained you all these points in detail in the class, right? By giving you examples what exactly it means. But right now it is not the time to get into those many details. But in such situation also, what happens that if there is some person who is inducing people to enter into such agreement to acquire shares, agreement to sell shares, agreement to underwrite, right, agreement to just get the benefit of profit by fluctuations in prices, or to enter into an agreement because you want to get some credit, or you want to get some loan from bank, right? So you are inducing that particular person that you invest because you want to obtain some loan, right? So in all these cases, the person is going to be again liable for section 447, because apart from the directors, apart from the people who are involved or who are charged under section 34 and 35, there could be a lot other people who are actually involved and who are doing this. Likewise, in the league, we have another section called as section 8, which talks about punishment for personating. Personating is what? You are making an application in a fictitious name. I am Shivangi Agrawal, but maybe I'm making the name in Queen Elizabeth, right? So this is what it is, a fictitious application. Maybe you're making to get shares in some fictitious name, or maybe you're making multiple applications in different names. Like I'm making one application only in the name of Shivangi, one in the name of Shivangi Bhargav, right? One in the name of Shivangi Agrawal, right? So why am I doing this? This is personating, maybe to acquire a lot of securities, maybe not to be in the we have read the concept of beneficial owner, registered owner, so now you understand the whole scenario, right? Or I am otherwise inducing the company to transfer the securities in a fictitious name. So in all these cases, again, the person who is doing this will be liable for fraud, section 447. Okay, fine. Now we start with the different types of prospectus. The very first one, abridged prospectus. What is abridged prospectus? It is basically the short prospectus, right? So it is containing all the salient features of prospectus, what are specified by SEBI, along with every form of application. There will be an abridged prospectus, because the prospectus in original, they are of 300 350 pages, right? So nobody can actually go through the entire prospectus unless they are very curious and they are making a very huge investment and they are competent to read it. Then of course they can ask for full prospectus and they'll get it. Otherwise there is a abridged prospectus which is attached with every application. Fine. Then we have shelf prospectus. What is shelf prospectus? As the name suggests, it has a shelf life, right? It has a validity. Okay. Now, basically, it has a validity of 1 year, first of all. And shelf prospectus is not something which is issued for every type of securities, but only for some specific type of securities. Okay, so it is allowed only for that specific type of security. So there is a company, or I would say there are certain class of companies as SEBI may provide, they can file a shelf prospectus with the registrar. Why? Because they want to raise fund in phases. They want to raise funds here, then again they want to issue some securities here, then again they want to issue some securities here. Right? If they're doing this every time, making a prospectus, filing a prospectus, issuing a prospectus, it takes a lot of time. Right? So they make a prospectus, and when they're making the first offer, they will file it with ROC and they will make the public offer. Right? And this is going to be valid for a span of 1 year. Now, during this 1 year, every time when they are issuing securities, they don't need to re-prepare the prospectus because they already have a prospectus ready with them. Right? So what will happen is, if you're filing shelf prospectus, you only need to file information memorandum. The information memorandum will basically contain the details like what are the new charges which have been created. New charges means you have read in the entire chapter of charges, right? What is the new charge which has been created against any asset of the company? What is the change in the financial position of the company, right? So all these details. So when the second or any subsequent offer comes, before that, prior to that, you will file this information memorandum. An information memorandum along with the shelf prospectus, along with the prospectus which was originally filed, is actually known as shelf prospectus. Right? Now, it may so happen, see, prospectus which does not require to be reissued for one or more issues over a certain period, it has a validity of 1 year. Right? Information memorandum in PAS to 1 month prior to the issue of subsequent offer. This is going to be the content, effect. This is the prospectus, right? This I have already told you now. The only thing I need to tell you now is, if there is some person who has already made an advance payment, right, before the change of information memorandum, right, I have already given an advance payment that, okay, this is the prospectus, on the basis of this we are going to issue. Right, now the information memorandum is filed and I get to know, oh my God, the company's financial position is deteriorating and I don't want to invest this now. So the company will intimate to such person, and if that particular person agrees, great. If he doesn't agree, you will refund that amount within 15 days. Okay. So whatever subscription he has given, that will be refunded. Next is red herring prospectus. You will understand this very well in CMA finals, because basically you'll be reading about IPO, you'll be reading about SEBI regulations, right? But right now you have to understand that red herring prospectus is something which does not include all the details. I want to issue securities, but I don't know at what price the people will be willing to buy the securities of my company. So I have a price band. Maybe I can give my securities at 100 also, and I can give my securities at 500 also. So 100 to 500 is the price band. Whatever you want to quote, whatever you are willing at, supposedly you're willing to buy the security at 300, you will quote that, right? Now, if the closing price is 300, then of course you'll get it. If the closing price is 400, you are somebody who's only willing to pay 300, you'll not get it, right? So there is a whole system how it works, right? But there are complete details are not given in red herring prospectus. So company basically issues this prior to issue of a prospectus. Fine. So what you're doing is you're filing it with registrar at least 3 days prior to the opening of subscription list. Right. Now what they are doing, you have to give all the details of the prospectus and red herring prospectus also. It's just that certain details are missing. Now once You have filed red herring prospectus. There are people who have quoted the price, quantum, whatever it is, right? The offer is closed. Fine. Whatever is the variation, now you have the final prospectus. Whatever is the variation between red herring prospectus and final prospectus is actually going to be highlighted. Fine. So the prospectus is going to state what is the capital which has been raised by debt, by share capital, what is the closing price, right? What details were not included in the red herring prospectus, and everything is going to be filed with ROC also and as well as with SEBI also. Okay. Right. Fine. Now, the next section, or the next type of prospectus, that is deemed prospectus, section number 25. Deemed means this is not exactly as prospectus, but it is deemed to be treated as prospectus. So if there is a company which allots or agrees to allot securities with a view to get it offered to public. Now, I know that if I am a company and I am going to allot securities to public, I will be exposed to so many compliances. Babare, I have to issue a prospectus, I have to file it with ROC, I have to do this, I have to do that. There should be this in the prospectus. This information also has to be disclosed. Oh God. So what I did is, I hired an issue house, merchant banker, whatever it is, right? So I went to them and I sold them 500 shares. And I told them that you offer this to public, right? So I'm not making a public offer. I'm not exposed to all these compliances and regulations. Law says, wait. If you allot the securities by way of private placement with a view to get it offered to public, your intention is to get it offered to public, then this issue house is going to offer it to public through some document, and that document will be deemed as prospectus. And now that document must state all the requirements, must fulfill all the requirements of prospectus. It should also state the amount of consideration received, where can this particular document be inspected, it has to be signed by 2 directors, right? The rules of prospectus are going to apply to deemed prospectus. All this will apply. Ma'am, how will we get to know what is the intention of the company? Is it deemed in all the cases? No. See, if the company allots or agrees to allot securities with a view to get it offered to public, if the view is clear, of course, it is prospectus only. But why will the view be clear? Company will take a direct route of allotting securities if they're very sure. If they're using this route, that means they want to hide something, right? So we need to check. It may so happen that company has allotted the securities to issue house and issue house is offering it to general public. It's their call. They can do that, right? They take a lot of securities. They might offer it to public. So it is their call. They can do that. But how to get to know that whether company's intention was so or not? So we get to know, or we identify company's intention in these 2 cases. If company has allotted the securities and issue house or allottee has offered it to public within 6 months, they cannot take such call. That means it was pre-planned, it was pre-decided, it was company's intention to do so, and company is using this indirect route to make a public offer, right? Or when company has allotted securities to issue house and they're offering it to public at that particular point of time, this issue house has not paid the entire consideration to company. See, if I am a shopkeeper, I take the goods on credit and I tell to them that you give me the goods. When I sell these goods, I will give you the money. That is what I do, because I have a very clear-cut intention of selling it to public only, selling it to other persons only. If I have the intention of using it on my own self, I have the money, I'll of course pay it, right? The same goes over here. If the issue house has the intention not to offer it to public immediately, if they have this agreement that, okay, I am selling you, they are buying the securities, I am selling them only the securities, then the consideration will also be paid. Okay, so in these 2 situations, it is presumed that allotment was made with a view to offer for sale to public only. Okay, so that is deemed prospectus. There is another section called as section 28, again where we read the concept of deemed prospectus. But here, there are certain members of the company, there are a lot of cases when the promoters want to dilute their shareholding, right? How they want to dilute their shareholding? I have, let's say, 40% shares in a company. Now that 10% shares of this company I want to offer to public. Can I do so? Yes, you can do so. And you can do so according to the provisions, right? In consultation with board of directors. There could be individuals, there could be body corporates. If they want to offer their holding to public, it can be done only in consultation with board of directors. So the offer is made to public, and that offer document is known as deemed prospectus. Here, you don't have to comply with the minimum subscription requirement, minimum application, right? All these are not required, right? This document will be deemed as prospectus. So all the requirement of prospectus will apply here also, except a few. And members will authorize the company to do everything on their behalf. However, they will reimburse the expenses in this regard. Okay, I had this written this over here. Clear? Okay. Now, there is also called something as Section 37 class action, which basically I didn't tell you. If I'm talking about Section 34, 35, 36, usually it's not just one person who is affected by it, but it is a group of persons who are actually affected by the same, right? And every person is making an application, is going to NCLT, right? Complaining about this, complaining about that. So this is a class action section which allows a group to make an application. Okay, so this is nothing but a group action by investors. It is very cost effective, and of course it is very effective also otherwise, because there's a lot of weight in the application. There are so many people who are affected, and it is clearly evident on paper, right? Okay. Then we have Section 30, which talks about advertisement. So whenever you are advertising the prospectus, then that advertisement also must contain the objects, liability, share capital, signatories, and capital structure, right? Fine. Once you have raised funds from public through prospectus, you cannot vary those terms of contract, or you cannot alter the object clause basically. So alteration of object clause that we have read is exactly the same over here, right? So if you have unutilized money, then you cannot vary the objects unless SR is passed through postal ballot, and there is the details published in the newspaper, and the dissenting shareholders are being given the exit opportunity according to SEBI regulations. Fine. Okay. So this I have already told you. Now securities in demat form. Section 29. Every company which is making a public offer, and of course the promoters holding, that has to be in demat form only. Unlisted public company in demat form only. Others in demat form only. Voluntarily it could be in demat form or physically also, but now I would say this is actually obsolete, because now we need to have the securities in demat form only. Now Section 40. Section 40, one part we have already dealt with. The other part is underwriting commission. Can underwriting commission be paid? What is underwriting? Underwriting is basically a guarantee given by big issue houses, merchant bankers and all that. What they are doing is, they're giving us a guarantee because we are coming up with a public offer. What if the public does not subscribe to our security? So we underwrite our issue. 100% issue also must be maybe underwritten, 50% issue may be underwritten, right? So proportionately that comes out. Supposedly 100% issue is underwritten, right? So I wanted to raise funds of 50 lakhs. Now people have subscribed to only 30 lakh, and I have 100% issue that is underwritten. So 20 lakh these people will actually take, right? So that is how it works. For them, they get the commission also. Later on, they can do a lot of things with the shares, right? So what is the commission that may be paid? First thing, you can pay the commission if it is authorized by articles. Secondly, it must be disclosed in the prospectus. Thirdly, you're not going to pay any commission on the securities which are actually not offered to public. If you are issuing securities privately to some angel investor, to somebody like that, On that, you will not pay any commission. Okay. Then contract of commission will also be delivered to ROC along with the prospectus. The maximum commission that you can pay is 5% or the rate in articles, lower of that. In case of shares, in case of debentures, 2.5% or the rate in articles, whichever is lower. And here we are talking about issue price. Supposedly the issue price is 100. What is 5% of 100? That comes out to be 5. Supposedly in articles it is given that 4.5% of the issue price, then maximum you can pay is 4.5% only. Fine, maximum you can pay is 4.5% only. Okay, next we move to private placement section 42, read with rule 14. Right? So what is private placement? It is a way of raising securities privately, and it can be done by both private company as well as public company. So public company can also raise securities, issue securities and raise funds through private placement, and so can a private company do so. Okay, right. Now, there are two types of securities that we're talking about in this particular section. Type 1, non-convertible debentures, which cannot be converted into equity. And then there is other type of securities, right? So convertible debentures, preference, equity shares, everything is included in the other type, right? So first of all, I'll talk about others and then I will tell you the difference. What is the difference in this particular type of security, right? Fine. Now listen to me very carefully. How and what is the process? To issue securities through private placement, what you need to do is give notice of general meeting along with explanatory statement, call general meeting, pass SR. So you'll take the consent of your members that can we go ahead with the private placement. If they say yes, then you are going to go ahead with the same. Now what is going to happen is board will identify some person, because it is not a general offer made to any. You are identifying, okay, I am giving this offer to these 5 people to take shares. So privately, I am issuing shares to these 5 people. You can do that, right? So they have selected a group of persons who are identified by the board, and they're also known as identified persons. These persons cannot exceed 50. These persons cannot exceed 50, but ma'am, we have read something else. Or such higher number as may be prescribed. Or such higher number as may be prescribed. Right? So, you have identified those persons. You are going to issue private placement offer cum application PAS4 to those selected persons only. Right? Maximum 50, higher prescribed is 200. Right? So, we go by the prescribed, of course. So, 200 is the limit that we have. Right? But you have to remember this also to write in the section. Right? So, board has identified some person. They record the same. Within 30 days of recording, they are going to issue them this application. And they can subscribe by sending money through check. Within 60 days, you are going to go for the allotment. Whatever money they have subscribed to, you are going to keep it in a separate bank account. Point number 1, there will be no renunciation right. What is renunciation? The right to transfer. I have been given this right to subscribe to this particular security because I am the identified person. Now I say I don't want to take these shares, but they are offering at a good price. Why don't you take it? No, you cannot do that. This particular offer can be accepted only by the person to whom the offer is made. Okay. The record will be maintained in PAS 5. Right? Allotment, very simple. Within 60 days, there will be allotment. If there is no allotment, then refund within 15 days. If you don't refund, then there will be interest at the rate of 12% per annum from 50th day. If you allot, great, file return of allotment within 15 days and form PAS3, there is going to be penalty for non-filing. There are some additional points which you must remember. What is the additional point? What is the additional point? No new offer unless the allotment is completed or abandoned. See, first thing, whenever I'm talking about this private placement offer, or whenever I'm talking about this limit, it is basically for every security, right? It is not that it is the limit is in consolidation. No, it is the limit is individually for every type of security, right? So if I'm making an offer, let's say I'm issuing debentures to 50 persons, and I again want to issue some equity shares or some preference shares to again 150 persons. Can I do so? The answer is yes, I can do so. Right? If I want to issue to 200 persons, can I do so? The answer is again yes, you can do so. That is not the problem. But the problem is that one offer should be completed. That means the allotment should have been done. Then you can start with the other one. And you have to keep in mind the entire the limit which has been prescribed, right? When I am saying that explanatory statement has to be given, what are the contents which you will write in the explanatory statement? What are the particulars of offer? Which security I'm offering? What is the price at which the security is being offered? What is the valuation? Who has done the valuation? Right? How much amount you intend to raise? Other terms and conditions. So all these will be written. All these will be written. Okay. So I hope this is clear. Apart from that, if you do not comply, there is penalty which you can learn, and that's it. And one very important thing, that when we are talking about the limit of 200, then that is not going to include your QIBs, and that is also not going to include your employees under ESOP, right? So this limit of 200 is going to exclude both of these, right? So it is going to exclude both of this limit is for every financial year. So in the new financial year, the limit gets renewed and you again get that fresh limit. And the restrictions that we are talking about, it would be reckoned individually for every kind of security, as I already told you, right? If I'm talking about NBFC, if I am talking about housing finance companies, they are not required to comply with all these, right? If at all there is a company, maybe it is a listed company, maybe it is an unlisted company, it makes an offer, or you can say invite public, or what, not invite public, but it makes such an offer to more than the prescribed number. Let's say it has made a private placement offer to 250 people, right? Then what it will be? Then it will be treated as a public offer, and you need to comply with the provisions of part 1 of the chapter. Fine? So it will be deemed public offer. Of course, we're talking about a public company only. A private company cannot make a public offer. Okay? Fine. Okay, because directors is one such chapter which ideally should be read in finals, but holds a very important place in inter. So I'm getting it revised prior to other chapters. Right. So what is director? Director has been defined in section 2 clause 34, which simply means director appointed to the board of the company. Well, I can say a person will be treated as director not if he works as a director, but if he is designated as a director, right? So that designation or that appointment is very important according to that definition, right? Okay. Now, Companies Act says that when we're talking about the company or the board of directors, basically, they are the trustees of the assets of the company, right? The directors, when I'm saying it is collectively all the directors, or when I'm saying board, it is collectively all the directors. When I'm saying board of directors, it is collectively all directors. One individual director does not have the power. Okay, right? Directors or the board of directors or the board, they are trustees of companies' assets or properties because they are managing those assets. They are also the agents of the company because they are acting on behalf of the company on all the routine matters. However, clearly under entire Companies Act, there are certain powers which have been reserved for shareholders, right? Okay, So the shareholders have the power to in fact change the directors also. They can remove the directors, they can appoint the directors. So appointment, removal, all these powers are there with the shareholders only. Okay. If there is a manager in the company, he's not a director. That you have to very well keep in mind. When we are saying the officer of the company, officer includes a director. So whenever we say officer in default, we are also charging the director of the company, whoever is responsible for the same, right? Okay, some basics which you must know, that these are the minimum number of directors which are required in a company, and maximum is 15 in all types of companies, which can further be increased by passing special resolution. Only individuals can be appointed as directors. Board of body corporates or likewise, they cannot be appointed as directors, right? Before I take you through the resignation, removal, disqualifications and everything, there is first thing that you must know, that what a director does, or what are the duties, or what are the responsibilities of a director. They're given in section 166. You have to act according to articles. You have to act in good faith. You have to exercise all your duties with reasonable care, right? You don't have to involve yourself in a situation where there is a conflict of interest with a company with your own interest, right? So personal interest should be kept at the last, right? No undue gain or advantage, and you will not assign your office. What is assignment of office? That if I am going somewhere, I'm giving this director's position to someone else. No, you're not somebody who can assign your office. You don't have the power to do that, right? This is against the duties which are given. To become a director, the basic requirement is that you should be an individual, first thing. Secondly, you must have DIN. What is DIN? Director's identification number, right? So there is an entire procedure. How can you obtain DIN and etc., which you don't have to read in detail, right? But basically, you should have DIN. So every individual, if you want to become a director, you have to make an application to ROC for getting that DIN, right, in the prescribed form, and then you get that DIN, right? DIN is applicable once in a lifetime. That means one DIN is going to stay with you till the lifetime. No matter you become the director of this company, then you leave this company, you become the director of another company, it's okay, right? Secondly, you want to become a director, there is no academic or professional qualification which is being given, that you have to be a CMA, then only you can become a director. No, right? You are anyway welcome to become the director of any company, right? So there is no requirement. Secondly, there is no share qualification requirement. Earlier, there was a provision which stated that if you want to become the director of a company, you must hold the shares of that company, minimum this many shares. Right now, we don't have any such requirement. However, there could be any specific articles of association of any company which could say so. Right. So if that particular company says so, then you need to hold those shares. Otherwise, no academic qualification needed, no professional qualification needed, no share qualification needed, right? However, there is one section called as section 164, which states that you should not be disqualified, right? That means you are eligible to be appointed as a director if you're of sound mind. That means you are not eligible to become the director if you are of unsound mind. And unsound mind doesn't mean that your friends call you so. Unsound mind as declared by competent court. Secondly, undischarged insolvent. There is a whole phase or process of insolvency. You apply for insolvency, then you are declared as insolvent. Thereafter, there is a tenure, then you are discharged. Now you can start a fresh life. So till the time you are not discharged, you are undischarged, you are not eligible to be appointed as a director. You have made an application for insolvency, right? So you have applied, you have made an application. Right now you have not been declared as insolvent yet. So still you cannot be appointed as a director. Fine. So general grounds of disqualification. Let's see how far I have told you. I've told you this one, I've told you this one, I've told you this one. The next comes offense. If you have been convicted means found guilty. So if the court has found you guilty that yes, you have done this offense, it doesn't matter it involves moral turpitude or not, right? And you have been sentenced to imprisonment for at least 6 months. So any time in the past you were found guilty for any offense for which you got imprisonment of at least 6 months. Now, when that 6 months will expire, that means whatever was the tenure of your sentence, you were sent to jail for 6 months. That 6 months expired. From that date, 5 years have expired, 5 years have elapsed. Now you are eligible to be appointed as director. So during that tenure of sentence, you're not allowed. After that, after expiry of sentence, till 5 years, you're not allowed. Okay. If at all your period of imprisonment was 7 years or more, you are disqualified for life. You can never be appointed as a director in any company. Okay, clear? Next, if the court has passed an order disqualifying you, you cannot be appointed. Next, if you are a shareholder also, you are a director also and you are a shareholder also, or you're not a director yet but you are a shareholder and you have not paid call money, the company is continuously asking for call money, you're not paying the call money, there was a last day fixed for payment of call, you have not paid it. After that last date, 6 months have elapsed, 6 months have gone and you have still not paid the call money, so you become disqualified to be appointed as a director. Next, we have offense under section 188. I would suggest learn it as it is. Right now, we don't have the time to explain you what related party transactions are, right? But if you have done any offense in respect of related party transactions during last 5 years, you're disqualified. If you have not been allotted in under section 154, that means it is a non-compliance of section 152 basically, or if your directorships are exceeding the given limit under section 165. Okay, so you're disqualified. Fine. Right? Okay. Now, disqualification is checked at the time of appointment of directors, and we have another part. What is another part? Section 164(2). Now, if you are already a director of a company and that particular company has not filed its financial statements or annual returns for continuously 3 years, then my dear, listen to me very carefully. You are not eligible to be appointed, right, to be reappointed as a director of that company or appointed in any other company for 5 years. So you become disqualified for 5 years. If you are a director in any company wherein the financial statements or annual returns have not been filed for continuously 3 years, or that particular company has not repaid its deposits timely, redeemed its debentures timely, right? And this particular failure has continued for 1 year or more, then you are not eligible to be appointed in that company, eligible to be reappointed in that company or appointed in any other company for 5 years. Okay, for 5 years. They are disqualified for 5 years. Fine. But supposedly, I just joined this particular company. So I am a new director and I got to know, oh my God, this company has not been filing financial statements for 3 years. What do I do now? Now I become disqualified to be appointed in any company as a director for 5 years. Where will I go now? I didn't know all this before joining, right? So for the first 6 months from the date of appointment, this disqualification doesn't get attracted to us. So what you can do in that tenure, either resign from that particular company or rectify these defaults if you can and continue. Okay, so this is what can be done. A private company can provide additional grounds of disqualification under section 164(3). Okay, then we come to the appointment of directors. See, we need a lot of directors. Basically, the director have to be appointed in general meeting, because there is a lot of requirement. You need to have a resident director. Some companies need to have women director. Some companies also need to have independent director, right? So independent director, women director, resident director, there are additional directors, alternate directors, nominee directors, right? So there are so many type of directors which are actually needed to be appointed. You don't have to read all details at the inter level right now. So we'll read them at the final level. But right now you need to know some basics about the appointment of directors. What is those basics? We are talking about a public company, right? Okay. So in public company, whatever is the total number of directors, it has to be minimum 3, but let's say the company chooses to appoint the total number of directors as 9. Your articles may say that all the directors will retire at general meeting and again they will be reappointed or somebody else will be appointed. So this may happen. But if they do not say anything, what will happen at not less than at least 2/3 directors will be rotational directors. 2/3 rotational means what? 6. Out of those 9 directors, 6 directors will be appointed as rotational directors at least, and 3 directors may be appointed as non-rotational directors. If I talk about, let's say, Reliance, there could be Mr. Ambani who is appointed as non-rotational director. He is not going to retire. But out of these 6 directors, they are rotational directors. Now, out of these 6, one third of these, right? That means 2 director at every general meeting out of these 6 will be retiring. They can be reappointed, or in place of these, somebody else can also be appointed. You get my point? Right? Now, who selects who is going to retire? So the directors who are in the office for a longer period will be liable to retire first, right? If there are 2 directors who have been appointed on the same day, then there could be a mutual understanding. Okay, this time you retire, the next time I'll retire, right? Or maybe on the basis of some lots, we can pick up some chits and then that retirement may happen, right? So basically, this is how their appointment will be made and this is how they are going to retire, right? If AGM is not held, the retiring directors are going to vacate. If the AGM is held, of course, vacancy on such retirement is filled. It can be filled by reappointing the same persons or appointing somebody else in case of the retiring directors. Okay, fine. So the vacancy can be filled by the same person also or by some other person also. Disqualifications I've already told you. Next comes resignation. Okay. A director is allowed to resign. How can he resign? He has to give a notice to the company that I am resigning, right? He may also, it is not mandated on part of director, but he may send this copy of resignation to ROC also, because till the time everyone gets to know that he is retired, till the time he has a lot of connections, there's liability, there's a lot of things, right? So basically what happens, director, you want to resign, you give a notice in writing to the company, the board is going to take note of the same. Resignation is going to be effective later of the date of receipt of notice or the date specified in the notice. Supposedly I'm giving this particular notice on 2nd May, but I have written in the notice that I'm going to resign with effect from 10th May. So the resignation is going to be effective from this particular date. If there is no date which is given, the resignation is going to be effective from 2nd May, right? So the board will take note of the same and within 30 days, they'll display it on company's website and they will also intimate in DIR 12 to ROC. Okay. The promoter or central government is going to fill vacancy if all the directors resign. Fine. So you can send a letter informing the chairman or the secretary of the company that you are resigning from the post of director. It is absolutely okay. And once a resignation letter is submitted to the board, then the director ceases to be the director. He is not a director anymore, right? It doesn't matter you have informed to ROC or you have not informed to ROC, right? immediately after this particular board meeting, right, whatever general meeting is held, in that also it will be, you have to place this fact of resignation in front of the members, right? If we want to remove the director, can we remove the director? See, if the board wants to remove the director, it is not possible. But if the members want to remove the director, then it is possible. Eligible member, that means if you are a member who is holding at least 1% of voting power or 5 lakh, then you are an eligible member, right? Or collectively you may become an eligible member. So if you're an eligible member, you can send a special notice for removal of the director or for appointment of somebody else in place of that particular director. You have to send it 14 days before the general meeting to the company. The company will send a copy of it to the director. The director can always make his written representation that why you want me to be removed. I have done so much of work, this, that, etc., etc. And they'll send it to the company. The company is going to forward it to all the members 7 days before general meeting. If it is not possible to be sent, it will be read out at the meeting. Apart from that, the director will also have an opportunity to be orally heard at the meeting. Thereafter, at the meeting, all the members will take a call, they'll take a decision, and just by passing ordinary resolution, they can remove the director. Whatever vacancy is generated, it can be filled. If there was somebody else who was proposed, then that particular person can be appointed. If no, then it will be treated as casual vacancy, as in this case also. The resignation of directors is also as good as a casual vacancy, and casual vacancy is filled by the board. Okay, so if a director resigns, then the board appoints in place of that particular director. Right? What are we going to pay to the director, ma'am? See, we have a contract with the director, what we want to pay. If I'm talking about managing director, whole-time director, because there are two types of directors. One are whole-time directors, which are also called as executive directors. Then there are non-executive directors who are not actually the employees of the company. They're part-time, they're independent directors, right? They're different. When I'm talking about the remuneration, we have manager, we have whole-time director, we have part-time directors, we have independent directors, we have women directors, we have so many directors, right? Section 198 gives us the overall managerial maximum remuneration which can be paid in a public company, and that is not going to exceed 11%. Ma'am, the total remuneration paid to whom? Only the managing director and whole-time director, or collectively to all the directors or manager? All the directors plus manager. 11%. 11%. Sometimes the company may not have adequate profit. We also have Schedule 5. We have a lot of detailed provisions about which you don't have to read right now. Basically, what happens in a company, the company fixes the remuneration per month, right? At the end of the year, they have to review that this is the profits that we have made. 11% of these profits comes out to be this. This is the remuneration that we have paid. If we have paid excess remuneration, we have to recover it. If we have not paid excess remuneration, great. Right? So the directors cannot fix themselves the remuneration. There's an upper capping which is given under law only. Managing director or whole-time director, they can definitely be paid on monthly basis or as a specified percentage of profit. That is not the problem, but then you have to keep in mind the overall limit. What is remuneration? Remuneration is basically the money or any equivalent thing which you're getting for the services that you are rendering. What you have to remember is one thing: a public company can pay remuneration to all its directors. Executive directors, non-executive directors, maximum 11%. Maximum 11%. Okay. So this is one thing that you all must remember. Apart from that, you also have something called as powers of board in the chapter of directors only. So the board can do all the acts which a company can do. Right? You cannot do something which has been reserved only for members. Right? But then there are some powers which are exercisable at board meeting only. Ma'am, what does it mean? Board takes all the decisions at board meeting only? No, my dear. Board may take some decisions through circulation also. That means if there are 4 directors, there is one matter which needs to be resolved. It is being sent to everyone's place. That means the board resolution is circulated and thereafter it is passed. right? And there are certain matters for which you need to call a board meeting where all the members will, where all the directors will come, they will meet, and then only they can take a decision, right? So there are certain matters which can be resolved only at the board meeting, and they are, if you want to call make calls on shares, if you want to go for buyback, issue of securities, borrowing of money, investment of funds of the company, giving loans, right? Approving financial statements, board's report, right? Diversifying business, approving amalgamation or merger, right? Any political contribution if you want to make, right? Takeover, appointment of KMP, removal of KMP, or or any other matter which may be prescribed. Okay. Now, these three powers, I call them big powers: borrowing, investment, and giving loans. They can be delegated also to any specific director, any committee of directors, or any managing director, any principal officer, likewise, right? So after this, we have operational and financial control that we're not revising in this particular session. Hope you all enjoyed this. Thank you.